হ্যাঁ বলেছো? আচ্ছা ভেতরে
May I
দিকে চালানো ওই তো বসে গেছে, ঠিক আছে।
may I have your lordships kind leave to mention the matter WPA 2635 of 2022 with 610 of 2023 for inclusion in your lordships list for hearing of the matter.
Hearing matter or
Hearing,
motion?
hearing matter, lordship. As because your lordship earlier has directed that lordship will be taking the hearing matters on Thursday onwards. On Thursday.
লর্ডশিপ,
Grateful, your lord.
লর্ডশিপ,
My lord, to move
My
the
lord,
matter.
two
My lord,
matters
urgently-
relating to extension of the interim order.
Can you just mute?
Interim order has been expired admittedly since file was in
Because
Calcutta.
otherwise it will be
And
overlapping.
this is a common
My lord,
order
this is-
relying on the
My lord, to move a matter, my lord, urgently before your lordship, my lord, tomorrow at 2 o'clock, subject to your lordship's not convenience. My lord, the issue is this, that your lordship is aware of, my lord, the fact that every political party, my lord, has a basic right to the right of dissent and, my lord, to hold a procession and a public meeting, my lord, that has been preserved by the Supreme Court as well as this honorable court in various judgments. My lord, it is shocking that yesterday evening, my lord, the police, my lord, rejected our proposal, my lord, to hold a public meeting and a rally, my lord, in Jalpaiguri, my lord, citing the reason that on 21st July, there will be a public meeting which would be held in Dharmotala by a particular political party being the ruling dispensation. But Dharmotala and Shiliguri, my lord, has a distance of 470 kilometers. My lord, the police officers here, my lord, with respect to, my lord, a public meeting which we want to hold here, my lord, is rejecting our prayer, my lord, on that score only.
You file it.
My lord, I'm only, my lord,
File and serve.
my lord, we will serve it, my lord. We will serve it by today, my
File
lord.
and serve, it will appear as
লর্ডশিপ,
My lord, only, my lord, why, my lord? Because, my lord, we have very less time. Your lordship knows, my lord, till Friday, my lord, your lordship's bench is sitting. My lord, only, my lord, I'm beseeching, my lord, because this would be a matter, my lord, which would be hotly contested, my lord. My lord, only I'm beseeching your lordship, my lord, that if on that particular day, at least we can indicate.
what is super urgent that you have to hold
My
a
lord,
meeting that day.
my lord, yes, my lord, because, my lord, there are burning issues, my lord, which are there. My lord, secondly, my lord, with
There only that day.
no, my lord, this, I'm telling your lordship, my lord, why on that date, my lord, this honorable court previously also, my lord, has permitted our political party, my lord, which is the main political party, to hold a public meeting on that particular day, saying that there should be a level playing field.
You file it, we shall see. It will appear in.
লর্ডশিপ,
My lord, the problem would be
I'm
that,
not allowed upgradation.
my lord, I'm not seeking upgrade, I'm seeking leave, my lord, so that I
You
can,
file it, I'm telling you, you file it.
but my lord, if the leave is not given, my lord, it would appear after 48 hours.
Also, it will appear
My lord, then, my lord, it would be Friday. My lord, that would be the last working day. Your lordship knows, my lord, it would be a basic, my lord, problem. My lord, over here, my lord, otherwise, I would not have, my lord.
21st is far off. You file.
My lord, today, my lord, it is not about 20. I'm beseeching your lordship. My lord. Today, my lord, what will happen, my lord? Previously, also, my lord, in a circuit bench matter, my lord, similar view was expressed, my lord, by a coordinate bench. My lord, what had happened is that the police officers then they came forward and said that no, they require 7 days time minimum to, my lord, organize a public
There
meeting.
is time. Even then there is time. 21st July is more than 7 days far away. Please don't press for these matters. Yes, next.
Lordship. Lordship.
It has already been mentioned by my lord, it is not appearing in the list. So directed to file a report. The report has not been filed. Let it appear under the prayer for extension. No problem.
But there are two matters relating to extension of interim order. Admitted, my lord, interim order has been expired since file was lying in Calcutta High Court. And now file has been sent to your lordship's order. This is a common order passed by the division bench, relying on the division bench order. Hundreds of matter moved. That is relating to my lord vacancy of fair price shop.
Mr. Shahara,
So it may be,
if interim order has expired, why don't you take out an application? It will appear immediately. Because if it has
difficulty-
expired, it needs to be reimposed.
that's true. Absolutely correct, my lord. But this is a matter where, my lord, at least
I
500
understand
matters
it
are.
will be a matter of course, but then let there be an application on record. That will be a wrong practice then. After expiry also on the same application, extension on the same application permissible. But after expiry.
As your lordship. I shall file it tomorrow and I
Lordship.
shall mention
Yes,
it, my
yes,
lord,
yes.
so that it
File
can
it
appear.
extended
Lordship.
on the report, it will appear.
Get, Lord.
Lordship, may I indulge?
Give it.
Hearing.
Lordship,
Directed to file in operation. Till date, they have not filed.
What is the matter?
Matter is about that, the petitioner was, dealership was cancelled by respondent authorities arbitrarily. Matter was last heard on 1st of May. They were directed to file affidavit, exchange of verification were asked for, but they have not.
Give, will appear. I don't know all these matters. If they appear, I will not be able to take all matters. Let us,
At least to be mentioned.
Lordship,
to be mentioned.
Lordship,
Hearing matter. Right?
Lordship, may I indulge to mention one
Please,
extreme
let
urgent
the
motion?
mentioning, oral mentioning be completed here,
Lordship,
then we see.
Lordship.
Yes, Honorable Court has directed the state to file a report. The repetition is due to an unauthorized use of my land for a transmission by a state enterprise, which is WPSCTC. It has carried out a transmission project on my land without taking prior consent or issuing any notice and without providing.
নিয়ে নিন ওটা মোশনে চলে আসবে Here is motion.
My lord, with the lordship.
Well, I am led by virtually.
Yes.
My lord, with the lordship,
Lordship.
I mentioned this matter, my lord. It is a very short matter, my lord. The urgency is, my lord, a person who is not disqualified by virtue of the statute is holding a public office. My lord, pleadings are complete. I will not take more than 10 minutes. There are judgments, my lord, supporting my case, my lord.
Hearing matter.
Hearing matter, my lord. I will take 10 minutes, my lord.
Will appear in the hearing list. I have taken
Lordship,
hearing
may I
minutes
leave
for all
mention?
from all of them and
Lordship, may I leave?
Grateful, my lord. Grateful.
Lordship, may I leave to mention one extreme? Lordship.
138. ও 138 কোনোদিন আসেনি বলছেন তাহলে নিউ মোশনে না থেকে মোশনে চলে গেল নো অর্ডার হ্যাজ বিন পাসড তাহলে তো এটা নিউ মোশন হবে ভুল হচ্ছে ওটা দেখে নিন কালকে মোশনে দিয়ে দিন
Lordship, may I leave to mention one extreme urgent motion? Extreme
Yes.
urgent motion, the petitioners before your lordship, they are served with a eviction notice from their residence, which they are enjoying for near about 100 years since their predecessors. In the meantime, the Devotar Trust Board, led by District Magistrate Kochbiar, has been served a notice for eviction to the premises by Friday of this week, lordship. Lordship, so let the matter be, leave may be granted to move it tomorrow, lordship. My junior
If
is
you
there.
file it will appear in due course. File it will appear in
Lordship,
due.
and they will be evicted, lordship. They will be evicted. No opportunity has been given for hearing to the petitioners.
Who
And
will be evicted? By what process?
Simply an eviction notice is issued that you should vacate the premises by within
Who has
15 days.
issued? Which authority has issued?
The district magistrate Coachbihar being the chairman of Devotar Trust Board Coachbihar.
So you challenge it, you have filed a writ petition, tell them that you have filed a writ petition.
Lordship, there is one correction.
Lordship, at least let it appear on Thursday, Lordship.
You file it today, it will appear.
Lordship.
Correction of the order.
Correction. What is wrong?
Only the state it was written, but it will be the respondent. I am representing the central.
Oh,
And in the middle, there is 7, it will be 8. I have corrected.
very.
May I mention a matter?
It for correction diye deben kalke upor.
May I mention a matter for inclusion in the list?
Mention it.
Okay.
My lord, my learned senior was supposed to appear online, but this is regarding extension of interim orders. I got 2 matters.
Extension, or order is subsisting or order gone?
My lord, it will be expired.
Will expire
Will
when it's
expire.
subsisting.
My lord, I'm not very well versed. since
If
he
it
was
is,
supposed-
if it has not expired, then it will appear. If it has expired, then you file an application for extension and reimposition, because that order is not there. What will I extend? I have to reimpose and then extend.
Yes, my lord, certainly.
You
Right.
check it out and then hand over the slip if it has if it is subsisting.
Okay, my lord. Grateful.
I'm for the Coachbihar municipal.
For the state, madam.
What is your name, sir? Name?
Alok Shah.
You are the advocate on record.
Yes, your lordship.
Mr. Alok Shah, learned advocate on record for the petitioner, hands up a letter emailed to him by the writ petitioner
My lord, item number 2, I'm appearing for the petitioner, lordship. Lordship, there was an order dated 17th of June 2025, lordship, upon the respondent, that is WBIIDC, from giving effect to the notices dated 20th of February 2025 and the public notice dated 16th of May 2025, lordship. And lordship, there was an direction upon the respondent to file affidavit in opposition within 2 weeks, which is not filed till date, lordship. Lordship, kindly, my prayer is
The
that
interim order has expired.
no, lordship. The interim
Yes.
order is the interim order was for a period of 4 weeks, lordship.
2 weeks from 17/6.
Yes, lordship. Lordship, I'm praying that the interim order may kindly be
You
extended.
have
Lordship.
respondents.
Lordship, they had appeared on the previous.
No, on previous, but for mentioning, if you want to get it extended, you should serve a notice on them. It will appear again tomorrow, you serve a notice.
Lordship, I'll do that in due course of the day. I'm grateful, lordship.
Extend it, but in their presence.
I'm grateful, lordship.
After order record for in. This matter is appearing
3 to 18, my lord, I am yesterday
Yes.
something went wrong.
Yes.
But the tender floated by the respondent number 7 being the BDO. Thereafter, I have participated in the same. I was selected as the L1 bidder and accordingly work order has been issued. Work has been completed. Now I am paying for the release of the tender amount as well as the
Security deposit.
deposit, all the outstanding.
Who is appearing for the
Now-
state authority?
Last
Yes, sir.
Yesterday just I was intending to draw, tender was floated. Then thereafter, with regards to the execution of the work, the BDO has constituted, a committee for such inspection and verification to undertake in what extent the work has been executed in terms of the strictest sense of the work order which has been floated, I am just referring, which is for my consumption, I am referring to your lordship. Kindly see, to Sahib ke liye. Lordship, kindly see the second page, that would be better. Second part.
And may I have the copy of the?
No, this is for my just. Lord, kindly see with regards to these all these NITs, from 1 to the serial number around 16, 16 years, The in each and every work, there is found that there is a discrepancy, Just may I for a reference one, kindly see the serial number 1,
All these were supposed to be executed by the petitioner.
Exactly. So, they have not. Suppose the specification given. Locally made purchase some items were even installed. So, if your lordship see the serial number 1 to 16, all the discrepancies, that would be better, if we come back with the affidavit, disclosing everything, they are not entitled to any, whatever the work they have as of now undertaken.
And last occasion, they were supposed to submit a report.
We are
Last
submitting the
occasion,
affidavit, comprehensive affidavit we will submit.
The time was
The
extended
report
by
was there in
justice.
order.
Yes,
Justice
What-
extended.
You submit the report, then we shall see if affidavits. are required.
I think, because
Because,
report and
Mr. Chaudhary,
Miller.
there are orders, 2 orders of court saying that you should file a
Miller, true, because what happened after this order, the BDO has constituted, because we do not know, and he doesn't know even. The engineers, 2 engineers deputed for this purpose. They have verified, Then thereafter this report has been prepared and they have submitted this report, If your lordship sees the engineers, the person who have
Because
been
there is
deputed.
an order to file a report by way of an affidavit.
I
That
can
has to
file,
be sent
that
by
would be a delayed the process,
File it because there is an order of court, you should file it.
But the affidavit,
Advance
just
Because that order I cannot modify now. If
but the I have intent to file the affidavit, disclosing everything in the
That's
NIT.
right, but first this order.
That will be a
needs to
cryptic, then again it will be again a
No,
affidavit.
I'll say that you deal with the contentions also in the report in the form of affidavit.
All right.
That will
Then
serve both-
they do something.
That will serve both the.
Yes, that I am only seeking.
An advance copy be served so
Yes,
that
yes,
I can.
you will take an
Yes,
exception.
if this affidavit is being shown, then definitely you are entitled of a copy.
Yes. The petition.
5 to 18, I think so.
3 to 18.
3 to 18.
3 to 18 একই order.
That's not good. Oh, that-
19th also, my lord. Yesterday even it was, they were not present.
Yes, দেখি একটু।
ঠিক লাগে না, বাবু লাগবে না, বলছি।
This repetition is not maintainable actually. There is an appeal.
The confiscation proceeding, the DFO is the my lord.
Order record করুন।
On merit, your lordship will
It will appear as for dismissal tomorrow if they don't.
yes, yes, or grateful.
आप बोल दो पहले।
Hmm.
Lordship, for item number 20, short pass. Short
After-
pass over. Is my
after-
learning privilege on the way?
I'm grateful. Pass.
30 the hope.
My lord, item number 21, I am for the petitioner. My lord, my lord, my junior friend is there in court physically and
Yes.
she will hand over the affidavit of service.
What is the matter, sir?
My lord, in this matter, the petitioners are tea sellers who have entered into a business relationship with the private respondents. And we have paid around 1 crore 61 lakhs odd to the petitioner, and we have received only certain part of money. And later on, we have paid an amount of 50 lakhs, but no material was supplied to us. So we have filed an FIR before the Pani Tanki PS. There was no investigation, so we are compelled to file a writ petition wherein Honorable Justice Abhijit Ganguly, as his lordship was there, passed an order which is at page 25 of the
Yes.
writ petition. My lord, kindly peruse the order. The relevant portion is at page 25. I direct the officer in charge concerned of the concerned police station to bring any of the respondents number 5 to 10 in court today at 4 p.m. As it appears, for last 6 months, police has not taken any steps, and I am surprised that the state is supporting the inaction of the police when innocent citizens of the countries is suffering. In view of this order, at 4 p.m., since the police authorities could not produce any of the respondents and have not taken any steps for last 6 months, from filing of the FIR, my lord was pleased to pass an order, further order, that it appears that the relevant portion is at page 27, my lord.
Yes.
It appears paragraph 1 above the last one. It appears that the investigating officer and the officer in charge of the outpost have not taken any steps in respect of the FIR for last more than 6 months. As no steps have been taken by the police in respect of the FIR, the petitioner has come before this court. In fact, in the fact and circumstances, I hold that the investigating officer and officer in charge of the said outpost is wholly incompetent to hold the position in which they are working. Disciplinary proceeding is required to be initiated against them as to why no steps have been taken for the last 6 months in respect of the FIR. I am told that the disciplinary authority is the Commissioner of Police, Siliguri Police Commissionerate. The person should be removed immediately to some other post where they can act, but uh, it is but not as police officers. However, I direct Commissioner of Police, Siliguri
Yes, I have read it.
Police Commissioner.
Yes.
Yes. My lord, subsequent to that, and mandamus appeal was filed, whereby the Honorable Division Bench presided over by Honorable Justice Shobosachi Bhattacharya has waived that penal part. But my lord was pleased to hold that since a SIT, Special Investigation Team, has been formed for investigation, it should continue with that investigation of the FIR in the basis of the FIR filed by my client, the writ petition. Kindly consider page 36, my lord. Paragraph 4.
Yes.
It is further submitted by the respondent that a special investigation team has already been constituted subsequent to the order, which is now in charge of the investigation. It is apprehended by the respondent that the interference with the impugned order may be affected such investigation.
Yes, yes.
Subsequent. Yes, my lord. So, my lord, if my lord kindly peruse the whole order, the SIT was supposed to continue with that investigation. Subsequently, the private respondents have prayed for an anticipatory bail, which was rejected. But till then, they are at large. Not even no steps have been taken by the police. Further, a complaint has been lodged by the writ petitioner, which is at page 42, my lord. But still, that no investigation has not gone any further. No steps have been taken to recover by money. Since they are absconding, if we can deduct from that, police should have taken proper steps to against them, but police has not taken any steps.
Yes, all the proper steps have been taken pursuant to the FIR, but the investigation was duly handed over to the SIT. The SIT is conducting the investigation. My lord, at present, the accused persons I find from a report, I have an updated copy of the report, are all on court bail. The trial court has granted them bail.
The accused are on bail. They have been enlarged on bail.
That information is not available with us, my lord. As per our information, kindly consider page 39. Anticipatory bail was rejected.
That is there, but now there is a report which says that they have been enlarged on bail. So what remains now? Investigation will proceed.
Investigation is proceeding, my lord, and the latest, my lord, takes up the last fourth page of the report, but the first paragraph, towards the last part of the first paragraph, if I may read the relevant portion. That is the latest that has happened. On 3/10/2024, I, along with force, again conducted raid at Mainaguri PS.
Which page you are reading?
The fourth page. Where the signature of the inspector in charge is there.
Yes.
It's the first paragraph, last part. On 3/10/2024, I, along with force, again conducted raid at Mainaguri PS jurisdiction with the assistance of Mainaguri PS, but same result obtained as they absconded to avoid police arrest. At present, all the FIR named accused persons are enlarged on bail. And my lord, subsequent thereto, this non-judicial stamp paper has been seized from the custody of the complainant, my lord. Those have been taken into consideration. And a notice under section 91 CRPC.
The report does not contain any pagination. No?
Yes, my lord, I find that it is not paginated. That is, I beg your pardon for that. Well, as of now, the latest is that on 12/6/2025, a prayer has been submitted before the learned trial court, that is the learned ACGM Siliguri, for obtaining necessary order to collect the specimen signature of the accused persons.
So investigation is going on. What remains now?
My lord, then necessary direction may be given to expedite it because it has been a long time. The FIR has been.
The petitioner. I've asked them to file a report in the form of affidavit. Affidavit of service filed today with you.
Grateful.
My lord, Let there be a direction upon them to serve a copy of the report they have filed.
Report in the form of affidavit has to be served. Be served.
Deeply
লিখে দিন
obliged.
ওখানে with prior service of a copy thereof.
Lord.
Prior service of a copy thereof upon the learned advocate for the petition.
Deeply obliged.
Yes.
22, I'm appealing for the petition.
Proceed, I am for the response.
Yes, petitioner.
Last time the petition is there. Last time we have
Yes.
having
Am
a
I
part
audible to you?
on this subject.
Am I audible to you?
Line is there. Lordship,
Yes, Mr. Bhattacharya.
Yes. I'm for the petitioner, my lord. Lord will kindly say, before Lordship gets into
The impugned order is, where is the impugned order, Mr. Bhattacharya?
the impugned order starts at page 37. But before Lordship gets into the impugned order, let me just rush through the facts once.
38.
A refund was given to me upon my application, upon checking of my books of accounts, and thereafter, my lord, that was reversed by way of filing an appeal. In the appeal, they made out certain grounds against me. That ground was they had seen certain documents.
Mr. Bhattacharya, you were not represented before the appellate authority, or you were?
I was, for the namesake, I was represented, but actually my representation bore no fruit. Because, whatever I wanted to submit, the appellate authority, I prayed from the appellate authority 10 days time. But he never came back with an answer. Whether my prayer for 10 days is accepted or not, I do not know unless they give me a notice that you come and appear. So, there will be no harm done if the claim is once again heard. Because they have certain claims against me, I wanted to produce certain documents which are again in their portal only. It is not that some special documents I was going to produce. Those were my returns, filed from time to time, and those are in the portal. But be that as it may, I only wanted to show it tallied with my books of accounts. The revenue cannot be prejudiced on this because they have already issued me the refund, and a competent authority, after being satisfied, issued me that refund. It is not that the money was something meaningful. And my only humble submission is this, that let me be given an opportunity. I will go back before the appellate authority. Let him see my defense. If he is not satisfied, then obviously he will pass his order to law. Nobody will be prejudiced on that. And Lordship knows I cannot plead the facts in a writ court. I could have very well substantiated it with facts, but I cannot plead the facts in the writ court. I have to show only the illegality and I have to plead on equity. Because the GST tribunal is also not yet done. So I am undone, my lord.
Yes, Mr. Agarwal.
Yes, Lordship. Lordship, kindly see page 4, para 2.
Page 4.
Page 4.
Page 4.
Yes, 3.
3.
Roman 3. Or 3 number. Lordship, this is truly misleading of facts. I will read. I will take only one minute, Lordship. Your petitioner submit that the reason for seeking the refund is due to the inadvertent excess deposit of cash under the head central tax and state tax as unused balance amounting to rupees 13 lakhs remain in electronic cash ledger, which your petitioner is legally entitled to claim as refund under section 49(6) of CGST and rule 1981. Lordship, I have last time I have submitted cash ledger, Lordship. One page.
Yes.
Actually, whatever the TDS, whatever they have worked in the different organization, from that, Lordship know better that they will deduct the TDS. This TDS will be known as the electronic cash ledger, because once they accept yes, TDS is mine, the automatically our server will credit that amount to the electronic cash ledger. So electronic cash ledger means it is deposited by the contractor, third party. So this is the cash ledger. So what he is saying, yes, deposited rupees 13 lakhs in cash inadvertently is absolutely a wrong. And if the foundation is itself is wrong, so this REIT is not maintainable also, because if this 13 lakhs is accepted, then this credit ledger and addition to his 13 lakhs we have to consider, though he has not deposited. So that's why he is not attaching a single document to prove that they have deposited rupees 13 lakhs in cash. So that's why pure misleading statement. Otherwise,
Please wait.
otherwise, Lordship, yes, every person who having the cash ledger, they are entitled to get refund subject to the conditions if all the requirements, if there is no tax liability. In this case, they are having the tax liability. That's why firstly refund was granted. On the review, it is being review analysis, it is found that their turnover as per the TDS is high, difference of 80 lakhs. So that's why, because there is a process, once the refund is granted, it is a absolute order, or the proper officer cannot revise his order. So the provision is provided under 1072 that the department has to file the appeal. Appeal was filed, they have appeared, they have paid the time for 10 days, and the appellate officer has afforded the 20 days. After that, it was passed. Now, at that point of time also, REIT petitioner has not disclosed before the appellate authority that they have paid anything in the cash. My submission is that if this REIT petition is accepted with this averment, then it will be difficult for the department to admit this claim, because there is no 13 lakhs. So if the REIT petition is based on the false averment, it is dismissed in limine. This is my
misleading submission from the bar.
There is only the two things, either in the affidavit.
When was the order passed?
Lord, may I indicate one thing? May I indicate one thing?
Just a minute, I'll come back to you. Come back.
At 44.
Page 44.
44 is the operating part. .5, Lordship. The 16/1/2023, they have appeared, and order is passed on 5/12/2023. That means if 10 days is added, then it will be 26. But in spite of that, in our revenue department, we provide some reasonable opportunity. And moreover, Lordship, because if this submission is accepted, then for the department, it's a very difficult, because we have to add the 13 lakhs. That we cannot.
No, that is never my submission. That is never my submission.
That is there in the form.
No,
Either case to amend the amend his submission.
May I reply to this? May I reply to this? I have never prayed anything more than what you have given me already.
No, given is a different thing, because
no, that is what I am on. I am not asking for anything more.
Then why this is a statement? Inadvertently, I made the cash deposit.
Mr. Bhattacharya. May I answer first? May I answer first? Kindly. Lordship kindly comes back to page 4 once again. My sub-para 3.
Page 4.
Let us expunge this sub-para 3 from the petition. Let us, for a moment. Let us expunge this sub-para 3 for a moment from this petition. My humble question to myself is, will that defeat my cause of action? Will it have any bearing? I have only tried to substantiate how the money came. Now, Lord, will kindly notice one thing. What is the TDS? The TDS is a part of the GST payable to me. Say, for example, 10% is payable to me. My contractor deduct 1%, and I take the credit. I pay 9%. Now, when the refund arises, that arises solely on the basis of my books of accounts. Today they have, say, the contractor has deducted TDS at the rate of 20%, while my tax rate is purely hypothetical, while my tax rate is 5%. Then the refund arises. This has got nothing to do with extra money or extra claim. And upon that,
as a writ court, I will also not enter into the merits. I will not enter into the merits, but I am on some more basic. I am on some more basic question, Mr. Bhattacharya. The order was passed on 5th of December 2023.
That is a very pertinent question.
Why is the approach in 2025?
Yes, very
Where is the
pertinent
explanation in
question.
the writ
I,
petition?
I actually wanted to address your lordship on this because that is the only pertinent question in the whole writ petition, which my learned friend has not yet taken up. I am grateful that lordship has taken up the question of this. There are two things. Number one, I will submit very candidly before this honorable court. I cannot improve upon my facts. What has been done, it has been done. I will neither try to hoodwink the court, nor will I try to weave some story showing the things that are not there. Now, what has happened, I'll tell you, your lordship. Yes, there has been a delay of around 1.5 years. That I cannot refute. But what I am on is this, refund, interest. These are some substantial questions or substantial rights of an individual, which the person has already enjoyed. And now, my lord will see, there are so many reasons for which this person was not, he could not approach.
Those reasons have to be spelled out in the writ petition.
Spelled
Mr.
out in the
Bhattacharya,
writ
by way
petition,
of submission from the bar.
but since, my lord, I will only say this, that the reasons are not very document evidence worthy. This I must say. The reasons are not very document evidence worthy. The only
Even
reason,
if it was not, if the reason was such that it could not have been substantiated by documents, at least
the only
a
reason,
word of mouth,
yes, that is what
at
I'm
least a
saying.
word in pen should have
My
been.
lord, that is what I'm saying. They were
It cannot
waiting
be
for
like
the
that I come up, I wake up in slumber, come up any day after 1 year and file a writ petition, get an order, walk away. It can't be
Two
like
things. One is they were waiting for the GST tribunal to occur because this is a question which is substantially relating to facts. So they were waiting for the GST tribunal to be done. So there is one thing.
That also should have been spelled out in the writ petition.
Spelled out, must be. I tender my apology for that.
Mr. No, apology will not do, Mr.
No,
Bhattacharya.
my lord, only thing
For
is,
me to exercise discretion
Right.
cannot be exercised
Right.
in thin air. For me to
My lord,
exercise discretion, you have to give me some basis on which
my
I
lord,
can stand.
subject
If
to
you don't
correction.
provide the floor, I'll fall.
My lord, subject to correction from your lordship. Subject to correction from your lordship. Only two things I will say. Number one, as lordship has rightly pointed out, the question of distinction, being a writ court, it's a court of equity.
I would
Limitation
have understood, Mr. Bhattacharya. I would have gone a step ahead and said that yes, this order still cannot be sustained. I would not exercise my discretion in favor of dismissing the writ petition by holding it to be delayed. If you could have demonstrated that the order passed is wholly without jurisdiction, I am convinced that the order has been passed. There may be an error of jurisdictional, but the jurisdictional error is within jurisdiction. It is not an error without jurisdiction. If it was an error without jurisdiction, then in that case, yes. Beyond jurisdiction and error, definitely writ court will intervene. But if it is an error which is within jurisdiction, an authority is as much entitled to pass a wrong order as it is entitled to pass a right order. That will be corrigible in appeal. But here we are on a more basic question, Mr. Bhattacharya. You are before the writ court under Article 226. There are certain parameters well laid down by the Honorable Supreme Court, followed by all high courts, have to be followed. That the person who is approaching the high court must approach within a reasonable time. What would be a reasonable time would depend on the facts and circumstances of the case. Now, nothing of that sort has been mentioned here. How will I presume?
My lord, page 14.
Page 14.
Page 14, para 19, lordship kindly see.
Para?
It is a para 19.
Page 14, para 9.
19.
19.
XIS. A semblance of a reason has been carved out here. The only thing is this, that they were waiting for the GST.
Not
price.
satisfactory, Mr. Chakraborty
Bhattacharya.
Bhattacharya. It says that he was waiting for the appellate tribunal to function. So it is
Yes.
still not functioning. So he'll wait for 1 year, 1.5 years.
That is why he has
A person who is who is so wanting to challenge an order because his substantial right, as you said, has been hampered because of one grant of refund. Will
kindly consider this question on a different angle. The state who was responsible to make out this appellate tribunal did not make out. Will they be allowed to take the advantage of not making out of the appellate tribunal? It is they who have not made out the appellate tribunal, who have not framed the appellate tribunal. Now, will they be allowed to take the advantage of this? Can a person take an advantage of his
It
own
is
law?
not a question of them taking advantage. It is a question of the High Court entering into a matter where you are not vigilant.
No, no, true. It is not
You be allowed to take advantage of a situation.
Right,
You be allowed to take advantage of a situation when your own rights are under
I am not taking any
under
advantage.
doldrums.
I am at the receiving end. I am only praying for an opportunity.
You are at the receiving end, therefore you ought to have been more vigilant. Your approach should have been more expeditious than
For
it
the
is.
last 1 year and a half, they have been issuing notifications that this tribunal is being set up. This is the procedural rules.
Very well. So do you mean to say that in these last 1.5 years, no writ petitions were filed challenging appellate orders?
That will not the petitioners are different.
Then
Petitioners are different.
This argument does not cut ice, Mr. Bhattacharya.
My lord, kindly appreciate one thing.
I could have understood, because you see, there are two things which are against you prima facie, rather ex facie. One is that you were granted 10 days time on your prayer to file documents. You did not file. You say on the contrary that they should have informed me a date on which I would go and file.
Yes.
This is something which I have not seen. If the authorities, if you go and pray before the authority that I'll file documents within 10 days, it was upon you to file it by way of a letter, a covering letter, that these are the documents within 10 days I have filed.
Unless they give me a date of hearing, how will I go and appear before the authority? They should have given me a date of hearing for placing of the records. If they have not done that,
in all cases where you take time, in all cases where you take time, it becomes incumbent on the authority to give you a date.
Yes.
You ask for 10 days time, they'll give you a date after 10 days for you only to file documents.
Yes, my lord. Otherwise,
and there is no obligation on your part to approach them within 10 days.
No,
Despite you having not been ready on the first day of hearing with documents, you having not provided the documents in the first day, there is no obligation on the taxpayer.
I cannot file the documents on the first day.
I can't.
I do not know what is against me. I do not know what is the. No, I'll tell you. If I do not know the allegation against me, I cannot substantiate the documents.
Very well. You did not know the allegation against you. Within 10 days, you are supposed to file. Within those 10 days, why you can't file without a date being without a date?
I have to.
That is why I want to. That is why I want to know how could you not file? Why should you not file?
I need to go to the officer. I need to make a note in the file, in the dispatch, and in the receiving on the file number that this has to be submitted.
Postal authorities are closed.
No, this is not post. This is 2000-page document. Cannot go in post. This is more than when these documents are shown.
So you will not approach at all.
Generally, a tempo is accompanied with these documents, my lord. It cannot go in post.
Yes. How would they approach is the question. Was the authority absolutely unapproachable?
Actually, if the assessee pray for the time, so if the assessee say that we want the next hearing date, the appellate officer will fix up the next date. Otherwise, we act on the prayer of the assessee. Assessee said
no. If suppose that if Mr. Bhattacharya's client had said that within 10 days I'll file documents,
right?
How will they file documents?
In the because physically or online or by post, because the address is given. Because on the personal hearing, when we are giving the personal hearing and we are giving the virtual hearing also. In the appeals, we are giving the facility of virtual hearing also. Both. When we are giving.
So for those 10 days, those documents can be uploaded on the portal.
Yes, uploaded on the portal or through by post.
Because I am not aware of this.
No, portal cannot be uploaded unless give me
Lordship,
the.
actually, the appellate authority is the, not the, it is a physical form.
It is
Physical.
there.
It is physical.
Physical form. In the GST, appellate form, it is not a faceless. It is a physical.
Yes.
You have to
Yes,
go
I-
because he appeared.
So he could have gone and submitted it.
He
Yes,
can
then
submit
Mr.
as another
Bhattacharya, where is the
thing.
difficulty?
Otherwise, Lordship,
My
in
lord,
the
kindly see. My learned friend is also at one with me that physical copy has to be submitted. It is there at,
Submit. What is the problem?
my lord, 2000 pages document. When I go and I cannot simply just place it on the table of the officer, my lord. There has to be a, there is a
Go
process.
and find it and take a stamp, come
But
back on the receipt.
yes,
Where
Take
do
a
I
stamp
find
on
it?
that to
My lord,
2000 pages.
let me tell your lordship. I cannot file a single document in the department unless the officer himself signs on the forwarding letter. Then only the dispatch will accept it. Otherwise, it will not. These are practical things that my learned friend
actually,
also
we are having the receiving section. If he,
And there
after
will
10
not-
days also,
There is no receiving
My
section.
2000 page document receiving section does not take.
it is only matter of 2000
This
because
is something which
personally,
is
I
unbelievable.
have deposited 10,000 pages.
I go before a tribunal within the period of limitation. I file a document. I need the judge to sign or the
No,
presiding officer to sign.
But
The
this is
receiving
a-
section will not take it. Receiving section will not take the documents. This is something Mr. Bhattacharya makes submissions which have some legs.
My lord, it's very unfortunate, Lord, but whatever I said was
Lordship.
harsh reality. Whatever I said was harsh reality, Lord. Because I myself have the experience and full of the, what should I say, my lord? I had been the senior standing counsel of the CGST. I had functioned for years for CGST. In my tenure as well, my lord, I have never made these submissions. Because we all know, unless the authority gives us the date, I cannot simply go and simply put the 2000 page document on his table.
You file your affidavit on this point that a date, unless you give a date, he cannot file a document. Let us see.
Grateful, grateful.
And one more thing, Lordship, he will file the document for 13 lakhs. Otherwise, this matter cannot be.
Not on 13 lakhs.
He will not file any
that is-
document. You just deal with this point that he could not have filed it because there was nothing available. And unless a date is given, he cannot file documents. This is something unheard of, Mr. Bhattacharya. Even I have not heard it. I have not practiced in that field in which you are practicing. But then this is something which does not come into reason. That
Well, I will just simply give your lordship one line. Nothing more, nothing less. What happens, your lord?
Okay, I will find
When I
that.
pray,
So
when I
direction
pray
may be
for-
given, Lordship.
when I pray for giving some documents, that prayer, unless answered in affirmative, I cannot go and.
no, this I don't agree with you. Your prayer, unless negated, is always answered in the
You know,
affirmative. That is the law.
I could have been, well, had it been a letter, I could have been given. But it was not a letter.
This is
the
you
body
are
of
asking them.
document.
You are asking them to be more philanthropic than they are. Don't do that.
Unfortunately, these documents should not have been submitted by me. It is there in their portal.
Very well. So then you could have indicated that it is there in the portal.
Unfortunately, despite my indication, they wanted to tally with my books of accounts. And
moreover,
Lordship, highly appreciate.
moreover, Lordship, there is the difference because he knows, because he is also the.
Is there anybody else practicing on that site? What is the procedure? The
My
document
learned friend used to practice. My learned outside used to
আমাদের
practice.
কি আছে আপিলে হ্যাঁ ফিজিক্যালি যে আছে কাগজ জমা করতে পারে ওই
Yes, yes, yes. 10108.
না 107 এ আপিল যে
Yes.
The documents are not accepted unless a date is given.
no
No, it is not document. The books of accounts, the whole thing. 2000.
Whatever may be the girth of the document, the fatness of the document.
A letter can be given in dispatch.
Mr. Bhattacharya, can you file an affidavit saying what you are saying now?
Yes.
Please do that. Please
I
do
will,
that.
because once my
Please
learned
file,
friend
put this on affidavit. Let this be in black and white. Put this on affidavit that it cannot be done, and I'll hold your client accountable for this because this submission cannot be lightly made and cannot be lightly let off.
My lord, I am not making it at all lightly. Because
Very well. If you are not making lightly, let it come on record by way of an affidavit so that your client can be held accountable that he could not have filed a document physically on any
It is
date.
not our document. It is not our document, my lord. It is
10
our
documents,
proof of
10,000 pages, Mr. Bhattacharya.
My-
Our document means a bunch of documents also.
Yes, yes.
That
yes.
much English even I am aware of.
My lord will not take me amiss. My lord will not take me amiss. Kindly appreciates the predicament
Because
of the
this has been going on for quite some time. A person will not be able to file a document unless a date is given. Although that person himself seeks time, this is too much for me to digest. You
My lord
put
will
this on
kindly
record by way of an affidavit, and I'll be
My
holding
lord
your
will
client
kindly
accountable
appreciate-
if he does not
My
stand
lord
for
will
what he has
kindly
said.
appreciate it is their appeal. It is not my appeal.
Whatever it may be,
I
you
cannot-
sought for time and now you have made out a case that you could not have filed the document on the day because you were not given a specific day on which you will go and file. You have taken
Exactly.
10 days time. You have taken 10 days time to within those 10 days, you could not have gone and filed it. That is a
My lord,
case which the court
that
has
is
to
my
take and
case.
believe.
My lord, that is my case, my lord. Kindly appreciate.
And where is that
cannot-
averment in the writ petition
Yes,
that you could not have filed it?
Yes, yes, yes. Lordship kindly see.
I have seen that
I
case
have
that there was no date given, but the receiving section will not receive any document without a date. Show me that averment.
Because receiving section will not receive. I did not even think of that. That can even be questioned. Lordship
Why not
kindly-
be? Why will not? Why will it not be a question? That is the only question, Mr. Bhattacharya.
My lord, once it falls from the
You should
court,
have been ready better on this then. That was the only question which you have to answer before a writ
once
in
it
this
has
kind of a
fallen
case.
from the court, once it has fallen from the court, I am ready to do it on a definitely. My
Where
lord,
is
I-
that averment in the writ petition? First show whether that averment is there in the writ petition that
Para
you
six,
are seeking to make
start
now.
from page 6, para 6. May I play?
Para 6.
Page 6, para 6.
Page 6.
Para 6. It starts from page 6, para 6.
Yes.
Accordingly, a personal hearing notice was issued to your petitioner by respondent number 2. Enclosing the entire memorandum of appeal preferred by the Revenue Department, hearing was initially scheduled for so and so. However, the hearing ultimately took place on so and so. Kindly
Yes.
appreciate, Lord.
Yes.
Because here on 29th,
No, don't explain. Show me the averment.
wherein the revenue representative Sri so and so appeared virtually and
I have
stated
read that, Mr. Bhattacharya. Paragraph 6, page 6, paragraph 6 does not contain that averment. Is there
he
any better
assured
thing
the
to show
appellate- last
that?
line, last line, last sentence.
Last
He
line.
assured that the appellate authority that he would submit additional supporting documents, including GSTR 3B7A9.
Yes, I have seen that. That averment is not
Then the
there.
next page. Then the next page.
Next page also I have
Unfortunately,
seen.
despite repeated prayers, next page.
Yes, I've seen that. Where is that averment that the receiving section will not receive the documents? 1,000 pages, receiving section will not receive.
How can I make that amendment? Because my case is this, that you have not given me date of hearing and I could not file. Why will I all of a
Merely
sudden?
because date of hearing has not been given, therefore you cannot file documents, cannot be the
That
case.
is my case. Madam, that is my case. Kindly
That case should not stand then.
Madam, kindly appreciate one thing. It is their appeal. I cannot upload a single scrap of document.
You could have filed those documents physically, Mr. Bhattacharya. You have not filed it. You have not filed it, and the excuse that you are making cannot be accepted. This excuse cannot be accepted that within those 10 days you could not have filed because a date was not fixed for filing.
It is not about within those 10 days. Once I said I will file those documents within the 10 days, the authority does not say anything. He simply records an order.
He does not even reject your prayer that he will not grant you 10 days. He does not even say, no, I'm not allowing you 10 days time to file document. He does not even say that.
How will I?
You have acted according to your own sweet
How
will.
will I?
You did not file. Then you waited for 1.5 years for the tribunal to function. Then the tribunal did not function. Then you have approached this court. Then you are making submissions which are not there on record. You say that yes, of course. You said that without date they will not take.
No, that is
The
what
commissioner has to sign. Only then it will be accepted.
not the commissioner, the adjudicating authority. That to me not came with the submission as the question came from my lord. It is only upon that question I answered. My only case.
Very well. The question is germane to the question. The question is germane to the case, which is why the question was put.
So my lord, I
Very
have
well.
no option to plead it in the petition, my lord. I
The
only
petitioner.
wanted to-
Lays
I
challenge
only wanted to say.
to an order dated. Yes.
My lord, I only wanted to say this, that the first thing is, I had prayed for some time to produce those documents.
That time was not denied. That time was not refused.
thereafter the only communication I received.
Very
was
well,
the
Mr.
order.
Bhattacharya, if anything new is to be added, then please add.
Can be submitted.
Very well, very well, then that repetition.
Only one submitted from the past. Lordship will not take me amiss. All we are doing is to represent my client.
Very well, but then I have also been on that side, Mr. Bhattacharya. So
know.
I
I
will
have
never put my case that high that if it falls, it will, even the fragments won't be found.
But I'm assuring your lordship that whatever I have said, that
Say
is
something, see, I am novice in this field does not mean that I will not be able to take assistance from people there. I am always ready to learn, but I should be taught the right thing.
Lord, kindly appreciate it is that whatever I have submitted is the case that the petitioner has. I cannot go beyond that. Lordship
Very
will
well.
not take me amiss.
The petitioner lays challenge to an order dated
5th December.
December 5, 2023, passed by the
Appellate Authority.
Appellate Authority under section
107.
107 within bracket 11 of Central Goods and Services Tax 2017. Full stop. Paragraph. The petitioner the case run by the petitioner in the writ petition is that the petitioner on November 24, 2022 had filed an application for refund of excess balance lying in the electronic cash ledger for an amount of rupees 13,00,000,000. Siliguri Commissioner by an order dated August 18, 2023. Where is the order of review?
Page 35.
35 is the yes, appeal. Grounds of appeal. Yes, review. It's not a review, Lordship, it's a order in review.
Correct me if I'm wrong on facts. Please correct me if I'm wrong on facts.
Yes, sir. Brother, I cannot hear your lordship.
Passed by the additional commissioner, CGST and central excise within bracket appeal, Siliguri appeal commissionerate being the appellate authority. Thereby setting aside the refund sanction order dated January 23, 2023. Full stop. Paragraph. Paragraph. During the said appeal, the petitioner was granted an opportunity of personal hearing, and petitioner appeared before the appellate authority on November 16, 2023. Full stops. During the hearing, petitioner sought for 10 days time to file, to submit GSTR-1, GSTR-3B, GSTR-7A, GSTR-9, and reconciliation statement along with other documents in support of the petitioner's claim. Full stop. Paragraph. The said hearing was taken on November 16, 2023, and ultimately the appeal was allowed by an order dated November 16, 2023. November 16, is it? Hearing was taken on November 16, 2023, and ultimately the appeal was allowed by an order dated December 5, 2023. Full stop. 5, 2023. Full stop. Being aggrieved by the said appellate order, the petitioner has approached this court by filing the instant writ petition. Paragraph. Mr. Bhattacharya, learned advocate appearing for the writ petitioner, at the first instance submits that the order in review could not have been passed without hearing the petitioners. That was a submission on the first day. Absolutely. Without hearing the petitioner. Full stop. The paragraph. He further submitted that the appellate authority while passing the order impugned, has acted in abject violations of the principles of natural justice by not granting the petitioner an opportunity to file the documents and papers which the petitioner sought to rely on, by making a prayer to submit the same within 10 days. Full stop. Paragraph. Mr. Agarwal, learned advocate appearing for the respondent CGST authorities, submits that the case itself is without any basis, in as much as the petitioner has himself admitted in paragraph 2 within bracket Roman 2II at page 4 of the writ petition that the petitioner had sought for refund due to an inadvertent excess deposit of cash under the heads central tax and state tax. Comma, an unused balance amounting to rupees 13,00,000 INR রিমান্ডে এখানে সেট আউট করলাম পেজ 4 সেট আউট paragraph 3 III. What was your next submission?
No, because because if this amount is considered, so we cannot give the effect of this amount because since it is not the position case. So that's why I have submitted the cash measure also to your lordship, where this amount is not appeared.
That I am not on that amount. I am not asking for anything.
I am just recording his submission. Even I am not going to decide that. As a recruit, I will. He further submits. He hands up a copy of an electronic cash ledger and submits that it is evident that the said amount of rupees 13,00,000 INR has not been deposited in cash by the petitioner, and that the fact that the said amount was not deposited would be evident from the electronic cash ledger. Full stop. Paragraph. It is also submitted by Mr. Agarwal that the writ petitioner is grossly delayed. Full stop. The writ petition is grossly delayed. Full stop. Paragraph. Paragraph. The writ petitioner has assailed an order passed by the appellate authority under section 107 within bracket 11. 107 within bracket 11 of the CGST Act 2017 by way of a writ petition. Full stop. Mr. Bhattacharya has submitted that the writ petitioner has assailed the order by way of a writ petition in as much as the GST tribunal has not yet been constituted. Full stop. On a query of the court as to why has the writ petitioner approached this court after 1.5 years after about 1.5 years after passing of the order impugned, Mr. Bhattacharya, passing of the order impugned, Mr. Bhattacharya has invited the attention of the court to the pleadings made at paragraph 2 within bracket XIX of the writ petition, XIX of the writ petition, to submit that the petitioner intended to challenge the appellate order before the GST tribunal. But since the tribunal had not yet been set up, the petitioner had to approach this court. Full stop. It is further averred therein that the matter gives rise to a continuing cause of action. Full stop. Paragraph. Having heard the learned advocates appearing for the respective parties and having considered the material on record, and this court is of the view that the writ petition should not be entertained. Full stop. Paragraph. During the hearing held on November 16, 2023, the petitioner had sought for time to submit documents within 10 days. Full stop. It is the petitioner's case that thereafter, i.e., after the date of hearing of appeal on November 16, 2023, no further notice was given to the petitioner, inviting the petitioner to file the documents. Full stop. In the opinion of this court, once the petitioner has sought for time and such prayer has not been expressly refused, there was no reason for the petitioner to conclude that the petitioner would be debarred from submitting the documents within the time requested for by the petitioner himself. Full stop. Paragraph. There is nothing on record to show that the petitioner ever attempted to submit the documents within the set period of 10 days sought for by it. Full stop. The petitioner's expectation that the authorities would issue a further notice inviting the petitioner to file documents, despite the petitioner itself having requested for 10 days time, and such request not having been refused by any order, whether oral or in writing. The petitioner's expectation appear to be outlandish. Full stop. Paragraph. It is not the petitioner's case, even in the writ petition, that even orally such request for time of 10 days was refused by the appellate authority. Full stop. In fact, it is noticed that the order dated was how was the impugned order served? How was the impugned order served?
By online also, by
It should have
online
been
we
served.
upload.
It was uploaded.
Yes, otherwise he is not able to get it.
It was uploaded in the portal and also served through dispatch.
The order impugn dated December 5, 2023. Was duly served upon the petitioner. Yet the petitioner chose not to challenge the said order within a reasonable time after service thereof. Full stop. The explanation.
I have never challenged the service. I have not challenged the service.
No, I know that. I'm saying that even after service within a reasonable period, you ought to have challenged. There, paragraph. The writ petition does not contain any explanation as to why the petitioner has made such a belated approach to court, under Article 226 of the Constitution of India. Full stop. The explanation given by the petitioner.
Cannot hear you, Lordship. Madam, cannot hear you, Lordship. I cannot hear you, Lordship. I cannot hear you, Lordship.
Yes?
I do not hear you, Lordship.
Connectivity issue. Full stop. Paragraph. Mr. Bhattacharya further submitted that what was your submission as regards the receipt of documents? Yes, that authorities will not, the receiving section will not receive it.
No, since it's a voluminous document, until the date of hearing is given, it cannot be submitted to the authorities because the file is needed to be kept.
Huh?
File is needed to be kept, because otherwise it will not be possible to submit those documents. Because without a file number, without
this submission is not the same which you made during the first.
What I said was the practical.
Period. It is settled law that a writ court, that a writ remedy is a remedy of discretion, and it and that ought to be exercised if the facts and circumstances justify exercise of such discretion. Since the explanation given by the petitioner, as regards the submission of Mr. Bhattacharya, that the order in review has been passed without jurisdiction. The order in review is unsustainable. Is unsustainable because the petitioner has not been given opportunity of hearing. This court is of the view that the provisions of section 107 within bracket 2 of the CGST Act do not mandate a hearing to be given by the authority concerned while taking a decision as to whether the authority concerned would carry an order up in appeal or not. Full stop. In fact, the provision of section 107(2) can be exercised even suo motu by the commissioner. Eta 107(2). The provisions of section 107(2) are quoted here. The quote for it. It is settled law that if there is power which can be exercised in terms of a provision provided in the statute, and such power has been exercised by the authority merely because the format of exercise of such power of this section under which we see the case of Onyx polymers, so that citation to within brackets. The citation.
We have only referred to one small fragment.
Yes, yes, please.
Land acquisition collector among the 1987.
Which one?
Versus land acquisition collector.
You are not properly audible. Please be a little louder.
Yes. Musammat Katiji versus collector land acquisition.
Katiji's case.
1987.
Very well. The petitioner refers to the case of MS Katiji. I'll place it appropriately. MS Katiji versus land acquisition collector. 89, na?
87 Supreme Court.
87.
The copy of the judgment is given by my judge.
This is from India Kanun.
Unfortunately, my lord, I could not get hold of 87 Supreme Court.
87 Supreme Court, 185.
Yes. Page number 3, internal page number 3. Internal page number 3, my lord. This ordinarily a litigant does not benefit from
Yes,
there.
yes, correct. Correct. That is there. The said judgment. Yes, the Honorable Supreme Court. The said judgment was rendered in the context of the power to condone delay under section 51 of should be section 5 of the Limitation Act 1963. And it was held that if there was sufficient cause was shown, delay must be condoned. Full stop. Paragraph. As would be apparent from the discussion made here and above, the cause shown by the petitioner in the writ petition for its belated approach is not sufficient at all. Full stop. In fact, there is no explanation as to why the petitioner kept waiting despite the order dated December 5, 2023 having been served upon the petitioner. the explanation that the petitioner was waiting for the functioning of the GST tribunal does not inspire confidence. Full stop. The petitioner's approach has not been vigilant, as would be evident from the fact that the petitioner did not submit the documents before the appellate authority within the 10-day period that was requested for by the petitioner itself. Coupled with that, the delayed approach before this court prevents this court from exercising discretion in favor of entertaining the writ petition. Full stop. Paragraph WPA 1171 of 2023 is therefore dismissed. There shall be no other instruments.
Only one humble prayer. This is something of routine nature, Lordship knows. Do not take me amiss. I'm praying for a stay of operation of this order for the next.
Stay of dismissal. Stay of dismissal is never done, Mr. Stay of dismissal will mean allowing the writ petition, reviving it.
And Lordship, I tender all my apologies if I have made your Lordship.
No, not at all. Not at all. You were doing your duty, I was doing my duty.
It might not be a very satisfactory order for the petitioner, but as a person of law, a student of law, it's a very satisfactory order as far as we are concerned, since all the contentions and submissions put forth by both the sides have been very thoroughly enunciated. The views might differ, but I am grateful for this judgment from your end.
Thank you.
Yes.
Next.
Good.
23.
I'm for the petition.
I'm for the respondent number 11 guy.
I'm for the state, my lord.
My lord, there is a liberty granted last circuit, my lord. There is a supplementary affidavit, my lord. I have served to the copy.
Yes, what is
My
it?
lord, there is a private respondent, my lord, 5 to 10. I have served but the same as returner unserved. Because the address not located insufficient address.
Some private respondents will be required or they will not be required.
They will be required.
But answering respondent is state, my lord, state authority.
Private respondents must be necessary. That is why you have made
My
them
lord, I have
stop them and come.
my lord, I have then my lord kindly allowed there is a civil suit is pending before the learned lower court, my lord. My lord, kindly allowed to serve the
What is your prayer?
advocate. My prayer is, my lord, I am the owner of the land measuring 4 kathas in LR plot number 251.
Yes.
251, my lord. In sheet number in Moja Dabgram, my lord. My lord, the private respondent filed a suit before the learned court below, my lord, judicial civil judge junior division first court, my lord, in Jalpaiguri. But my lord, can you see the supplementary affidavit? I filed the title suit, plaint of the suit. Now there is no mention in the suit plot. My plot is not mentioned in the suit plot. But the my lord, the police authority, concerned police authority, near police authority, stopped my construction work on my land. I have obtained loan from the respondent number 11. And before the loan, they have searched the title of the property and they said that in 251, there is no case is pending. But in respect of that, the state authority stopped my construction work over the land, on my land, on LR plot number 251. I have made 2 representation, but they are not allowed to construct on my land. Permit to construct on my land.
Civil dispute, how will the writ court intervene?
But only to that, just to continue my, they are illegally, my lord, without any order before the.
If I may elaborate a little, what has happened in this case is a case of purely mistaken identity of the plot concerned by the police authority. Now the petitioner has obtained a loan from me, from the bank, I am representing the bank, and is doing construction of his homestead, his home there, his house there. Now what has happened? A title suit has been filed by the private respondents, wherein an injunction order has been granted by the learned trial court. In connection with that injunction order, in the garb of implementing that injunction order, the police has been to the property of the petitioner herein and tried to stop him from carrying out the construction work. Whereas the property involved in the said title suit and the property of the petitioner are entirely different. The plot numbers are entirely different.
For the police.
My lord, if your lordship sees, I don't know which page number. Okay. My lord, the supplementary affidavit, my lord, which they have filed, my lord. The schedule states about the plot number, my lord, RS 3. The case which has been filed, my lord. It says RS plot number 383/665. Now given page number 8.
In supplementary affidavit.
Supplementary affidavit.
Yes.
So there is a schedule given. The schedule says plot number RS 383/665. And the injunction has been given with regard to this plot number. Now his plot number is also the same one.
No, Malad kindly
page
see.
73.
Malad kindly see.
Page number 73
There is also
of their writ application, my lord. Kindly see, my lord. 73, my lord.
Page 73.
73 RS plot number 383/665. So there is an injunction.
No,
With regard to this, there is an injunction, my lord.
Malad kindly consider this.
One thing, this is the mother arrest clause, and the injunction has been granted in respect of the LR clause. What happens in case of when it comes from the arrest to LR, the arrest plot may contain a certain quantum of, let's say, for instance, 10 acres. Subsequently, during the LR settlement operation, it gets subdivided into the names of the respective riots, and each of the riots are allotted separate these khatyans in their own names. In the RS Khatyan, there used to be a single Khatyan wherein the names of all the co-sharers are included and the shares are mentioned therein. That is not the case in case of LR Khatyans. LR Khatyans is by name only. One riot can have only one Khatyan. Now, my lord takes a look at the page number 8. Therein the LR plot numbers are also mentioned. The corresponding LR plot numbers are 359, 371, 374, 375, and 376. My lord, this does not pertain to the land of the petition.
No, from
That is the petitioner's LR plot number.
No, 251.
When he has taken the LR plot number.
Malad
Obviously,
251.
It is the arrest plot was never in his name. Arrest plot was in the name of his predecessor.
So that is required to be seen from where it has come. So this is a matter of jurisdiction of the civil code.
No, Malad.
You have not made me a party in the suit. No, I am not a party in the suit.
Yeah, he is a party. He is a party in the suit.
He is not a party in the suit.
Might be the bank is not a party, but he is a party.
Malad kindly consider that the LR plot number, my plot is LR plot number 251.
Let the private respondent come, otherwise it won't be.
Malad kindly to allow to the serve to the advocate on the private respondent.
Yes. Supplementary affidavit. I'll come back in 5 minutes.
Yes, sir, madam. 24 Lordship, we are appealing for Siliguri Municipal Corporation, led by Mr. Vijay from Das from the Bottom.
My lord, I am appearing on behalf of the respondent number 225, my lord, in this
Siliguri
matter.
Municipal Corporation, we are appealing for.
Siliguri Municipal Corporation, my lord.
Who is appearing for the petitioner?
They are not appearing such.
My lord, on the last occasion also they did not appear, my lord.
Likheni.
My lord, my lord, may I be allowed to make a submission, my lord?
Petitioner is not there. Why?
My lord, this is a very
The petitioner is not represented. Full stop.
Item number 25, my lord, I am appealing for the petitioner. Am I audible to lordship?
Yes, yes.
My lord, this is a settled issue, my lord. Kindly don't open the brief for a moment, my lord. Hundreds of judgments have been passed by several judges of this honorable court, my lord. The issue is that, my lord, we are my lord, I am a Sampur Sarok, my lord. working in a Madhyamik Shiksha Kendra. Madhyamik Shiksha Kendra is an institution, my lord, which imparts education up to class 8. These appointment are actually, my lord, on the basis of contract, on the basis of agreement, man, initially made among the school and the teacher concerned, my lord. Initially, the age of retirement from the said post was 65. My lord, in 2020, my lord, government has brought a scheme for these Samposaroks that if you accept your retirement at the age of 60 instead of 65, you will be given the benefit of para teacher, my lord. What the benefit the para teachers are getting, my lord? The para teachers are getting especially the benefit of EPF, my lord, Employees Provident Fund, my lord. And my lord, the scheme that explicitly, the scheme, my lord, it states that we are entitled to get the benefit of para teacher from 1st of December 2020, my lord. But instead of that, my lord, they have given me the benefit of EPF, my lord, from 1st of April 2024, my lord. We have approached before this honorable court stating that as you have not given us the benefit of EPF or the benefit to be given to the para teacher instead of 2020, but you have given it from 2024, my lord, we will not receive that. We will not receive that benefit. Certain teachers, my lord, they have approached before the authority that we will not accept the benefit. And certain teachers, my lord, who had accepted that benefit, the benefit for which they are going to give in, my lord, from 1st of April 2024, my lord. These two petitioners, my lord, accepted the benefit from April 2024, my lord. But in spite of expiry, my lord, more than 1 year, my lord, no benefit has been given to us. My lord, we have now, then, my lord, we have again, my lord, approached before the Honorable Court in November, my lord. Before my lord Justice Sengupta, Joy Sengupta, my lord. And this issue has already been decided. And the answering respondent is, my lord, Mission Director, the respondent number 2. And respondent number 2 has said that we have no objection if you revert back to the previous status, Samposarok, from the post of para teacher. That is a settled issue. My learned friend is there, my lord. He will hand over a copy to the judgment passed by my lord Justice Sengupta, my lord. These two candidates are, my lord, these two teachers are those candidates, my lord, who have accepted the benefit to get the benefit of para teacher, which has extended to them from April 2024, my lord. And they have now come that as the benefit you have said that the benefit will be given for April 2024, but in spite of expiry of prolonged period, my lord, you have not given. So I do not stay, my lord, I do not want to work as para teacher, my lord. This is settled issue, my lord. Several judgment by Madam Justice Sengupta, by Madam Anuruddha Rai, by Madam Shogoto Bhattacharya, my lord. This is an order passed by Madam Justice Sengupta, my lord, where appearing in the circuit bench.
So
Sitting in the circuit bench.
you want now to be treated only as
As
Samposarok?
And to work up to 65, my lord.
Yes, and you will forego the benefits which you would have otherwise got if you were to be treated as a parent.
They want to change their option now. Only change of option.
Only change of option, my lord.
The petitioners
My lord,
Well,
and
I
item
feel
22 similar matter, my lord.
item 26 matter similar matter, but only difference is that matter. Earlier matter we have paid for cancellation of the option which we have exercised to change our status and the DCA form, my lord. The data capture form which we have exercised to get the to take the benefit or to accept the benefit from April 2024. And this matter, my lord, we did not exercise the DCA form. We did not fill up the DCA form. We have stated that we are not going to accept the benefit of para-teacher, my lord, as it has been given from 2024 instead of 2020.
It will be the same. The earlier order was also the same, that your earlier option will stand cancelled and you will be treated as Samprosaro.
Yes, my lord.
And also the DCA, my lord, only the data capture format, my lord. Earlier matter, my lord, data capture format, my lord.
अगर read एकटू देखी Yes.
Well, earlier matter, my lord, we have also exercised the data capture format which is required to accept the benefit of EPS or the benefit of para-teacher.
So that will be cancelled. What format you have exercised?
Both should be cancelled, my lord. Option as well as DCA.
Very well. Option as well as the data capture format will be cancelled. যেখানে cancel লিখেছেন না, option exercise including the data capture format for receiving the benefit of EPF scheme will stand cancelled.
EPF, my lord, extremely obliged, your lordship. And this matter, my lord, we have not filled up the DCA form.
ছাপাবেন আমি একটু দেখুন।
And this matter, my lord, we have not filled up the DCA form.
হ্যাঁ, এটা আগেরটা আর এইটাতে এই লাইন ছাড়া আপনি একটা দেবেন তো ম্যাম।
Previous matter also DCA form has been cancelled, my lord.
This matter they say
In this matter, my lord, the petitioner did not exercise or the fill up the DCA form, my lord.
He has not.
Because we have
Previous matter, my lord.
Previous matter we have cancelled.
My lord. Gate.
Same order.
Obliged, your lordship.
Yes, my lord.
I'm for the CGST one.
এগুলো রয়ে যাচ্ছে affidavit of service এখানে রয়ে গেছে আগের ম্যাটার। What has happened?
There was a show cause, after show cause the application was done, but the application order was not uploaded in the CGST portal. As such, I could find my, they are paying for uploading of the application order in the CGST portal.
Yeah, your lordship, as per section 169 of the CGST Act, there is categorically mentioned that the order can be supplied through mail or through physical post or through messenger. Admittedly, they have received the order in original long back, that is in the year 2023. After elapse of 2 years, they have filed this writ petition with the plea that the order is required to be uploaded. But after amendment in the year 2022, there is in rule 108.
Physical copy of the order?
Yes, yes.
Now, Lordship, the clients were under the impression that full effect is now.
108.
The CGST portal, there's no records found. So unless the thing is ordered.
Page?
Page 70. No records found.
First to that. It's 70. No?
70 and 71. No records found. No records found.
Yes.
There may be some technical glitches. For that reason, order cannot be found. But there is a that's why in the statute it has been mentioned that the assessee or the petitioner can prefer.
Filed online or offline?
Online.
No, offline also. It is the position of law. Rule, it is rule 108. Rule 108. এটা দেখুন একটু দিন 108.
10?
Rule 108. Appeal to the appellate authority.
Rule 108. Rule 108.
Rule 108, may I read? An appeal to the appellate authority under subsection 1 of section 107 shall be filed in form GST APL 01 along with the relevant documents electronically and provisionally acknowledgement shall be issued to the appellant immediately, provided that an appeal to the appellate authority may be filed manually in form GST APL 01 along with the relevant documents only if the commissioner has to notified or the same cannot be filed electronically due to non-availability of the decision or order to be appealed against the common polder. So, if they did not receive any copy, in that case, permission is required. But admittedly, they have received the physical copy of the order. And after a lapse of 2 years, they have filed this petition.
No record of this, of the adjudication process. There's no record.
Moreover, regarding mode of service, as per section 169, if he did not receive the copy of order, in that
So if
case,
the proviso says so,
yes,
if the same cannot be filed electronically due to non-availability of the decision or order to be appealed against on the common portal.
on the common
So
portal.
it serves, it takes care of exactly the case that your client has made.
But the common portal says so that no record found.
So that is why it says that if it is not available, but it is otherwise available, you can file manually.
This provision has been shown to me, but I have confirmed from client, they are saying there is no process from online, offline application, offline filing of application.
It cannot be shown because due to some technical, that's why this
No, he's saying
proviso,
he cannot file manually.
he
There is a
can,
provision you cannot file manually.
he can.
They have sent me instruction that there is no process of filing.
No. It is a rule. It is mentioned in the rule. It is mentioned in the rule. Physical copy can be filed
No.
together with.
Also, can you transfer liberty to file physically the appeal?
You file physically appeal, but it will be subject to your limitation.
Limitation has been crossed. Has already.
That he will.
Yes.
Whatever if the authority
Yes.
has.
Not under decision of recruitment, but the application is applicable. Section 5 is.
That you take your point there. I will not condone from here. You take your point.
Yes,
there.
kindly permit to be grant me the liberty to file.
Yes. The petition.
be decided by the.
It is made clear that
Lord, I am for the stay.
One grant of the fictionary benefits and then the attribute to the petition. I'm not sure, last occasion, last Monday, the direction proposed the parental municipality to file a report. And then Friday.
Lordship, I don't have the report, but verbal instruction, Lordship, till this month, Lordship already paid to the petitioner, Lordship.
Friday, they had paid a particular amount, and just now they have saying that most of the receivable.
you take instructions, come
I have
back.
to take instructions.
When should I keep it?
10th, Lordship.
Now they should disclose by we have a report that how much they have paid and under
Very
what
well.
head.
You file your report. There is an order. Why are you not filing the report?
Keeps it
Lordship.
on,
File it.
Friday, his senior, keeps it on.
Friday, Lordship.
I'll report. देखिए
29.
I'm appearing for the state led by Mr. Laner AGP.
Same order.
Grateful.
No.
Fact that I prayed for approval. I could get passed on this. What has happened? There was no appointment last more than 20 or 25 years ago. But the post of teaching staff. Now, post of the headmaster was lying. The teacher in charge were functioning. Having the proper equipment for applications for the postal also, the 10 years experience, master degree, and then work.
কি নাম এই মামলার?
Now, the sum of the teachers can put this board. By finding the petitions, experience for approval, I will master of the same. Now, one of the coordinate phase of this board consider the matter and rejected, yes, if they have got the qualifications, then may not be consideration, approval is different. In terms of his decisions of the board, of the coordinate bench, they have taken a decisions that whoever the teachers are there, whether they are approving the post of headmaster, if they have the coordinate. Now, your lordships, can you have a look to this? My case, yes, my appointment was made as a head of the institute that pays 80 MAB as a teacher in charge with effect from 1/12/2023 by meeting the regulation number such and such pays 1H. Now your losses can be seen, this approval of the post of PIC was also accorded by the department, page 19. Then, my lord, the approval was also made by the district inspector of schools as a teacher to charge, page 20. Now, my lord, the coordinate bench, as per decision of the coordinate bench, will take a lesson.
Yes.
Now, my lord, so that judge, they are giving one of that approval, that's legal as circumstances, the point of the teachers is going to much. There's been versus 1900. They have got the requirement qualifications. They up to 27 candidates. They have been given approval as a headmaster. Got it?
Yes.
Immediately, by coming to know, I put an application before the authority that phase 23, and there I have made it clear the paragraph the details was given 1, 2, 3, and paragraph 4. When all the teachers have been appointed as the headmaster of the concerned school, I should not have been denied for approval of the. However, as my case has been left out, I believe in the group itself, as all other teachers have got their as headmaster of their subsequent. As the benefit has been given, pension of the employee, such benefit should be extended to all other employees who are can be accordingly approval and payment from the post of years also. Already was said to principle of law. If the decisions of the judicial decisions get reflected to section of the employer who are similar to situation, that must be exceeded into the various judgment is there, whether the 2022 SCC online. Page 641. Received by judges in Patel versus Bhatnagar Minister of Preparation. All of these aspects of the matter was considered. There are, like the Uttar Pradesh or with the Kumar Srivastava, there are 70 till what 6 and it's the mark or century.
Yes.
These are my submissions. I should not be left out when I have got the required form.
Yes.
Yes, Lordship, I am for the GTA, Lordship. Lordship, in the year 2003 to 2024, the School Service Commission has defunct from the in the hilly region, Lordship, in the Gorkhaland administration. But Lordship, 22nd January 2024, the government has reconstituted the School Service Commission, Lordship. So after the reconstitution of the School Service Commission, the GTA has no power to consider their representation, because Lordship, because now everything is in the hand of the School Service Commission, Lordship. Even they have not made the School Service Commission party in this writ petition, Lordship.
Then how was this notification issued? I mean, this order was issued on October 28, 2020.
Lordship, first of all, Lordship, I need to file affidavit in opposition in this case, Lordship.
Till date, the Service Commission Act has been suspended, Act has not been operated. Till date, till today, I'm aware that definitely instructed. Let them show that it is being operated.
Yes, Lordship, that's why we need to file opposition, Lordship.
No operation and no appointment by the Service Commission. So show it is when we have required the qualification, we got the qualification. It is not the case that we have below.
And first of all, Lordship,
lack of experience.
it
is not the case that we are not discharging our duty at the head of the mistake. So when all parameters are, and you have considered the matter in terms of the course.
If you have issued this kind of a letter,
Yes.
order at page 21 of the writ petition, why should these people be left out if they are similarly
First of all, Lordship, the headmaster post is a single cadre post. Everyone will come and say they.
But if you consider some people, you cannot leave out some people, consider some people, that will breed arbitrariness.
But Lordship, now the government has stopped us for further.
Where is that stopping letter?
Lordship, that's why I need to file opposition.
File a report in the form of a.
Lordship, grateful, Lordship.
Malad, from the state say, Malad, kindly come page 20.
It's 20.
Yes, ma'am.
Yes.
20, page 20, Malad. 21st March 2025. Only the charge was given as Malad, the assistant teacher in charge. And Malad, if your Lordship sees 28/10/2024, that notification has come. Page 21, your Lordship, please.
21.
Yes, Lordship.
28/8/20.
Yes.
Yes.
So when this notification, whatever, Milord, because these are the, Milord, again, the subject matter of the scrutiny by the Honorable Coordinate Bench of the Calcutta High Court, Milord, in different aspect. I am not. So, Milord, this at the time of event, assuming, while considering this approval, Milord, if you kindly see, this order is issued in compliance with the decision taken in the meeting of GTA Shobha on 24/10/2024. Approval, e-file number such and such. So, Milo, this was the decision of the pursuant to 24/10/2024. Decision arrived on 28/2024, and he has been assigned as a teacher in charge on January 2025. House in the list said person can be considered. So not cannot be considered.
Functioning, this is mere approval. Although approval is not required at all. The post of the teacher in charge is functioning as a requisite qualifications. The approval is the empty formality, approval by the.
Then why the notification then? Is it empty formality?
This is the court's order. If you lordships kindly have a look at this order of the. What it says.
Well, all will disturb by affidavit, my lord. Nothing can be, even the consideration order cannot be passed.
They cannot say that the section of the people I will allow, I will give the benefit. And some
We
of
are
the
not
people,
saying.
they will be deprived. It cannot be done by exactly what the.
There is no, my lord, indiscrimination, no inequality, my lord.
Very good.
Get full.
The petitioner
Your lordships kindly make it clear, man, otherwise
Yes,
they will be.
since Lordship's order is always a mandate, even. But then second half, my lord, my learned juniors will be there. I will be little the other assignment will not get.
But the next matter is
Next
also
matter?
different notional
Yes.
benefit.
31.
Notional benefit, finance approval.
Of the notional benefit.
Yes.
What has happened, I will tell you lordship. That the
That
First and Dispute Commissions, that are the golden exemptions. On a one day. Now, let the, after holding examinations, panel was prepared, but it was not going to be prepared. Thereafter, we have to come before this court, one after another relations. Then the court passed an order. This appointment for the entire candidate was kept alive. Now, it appears, this, if your lordship's kindly turn, it's 18. The order of the court.
Page 18.
Yes.
Yes.
Counsel for the petitioner submits that and all the issue involved in the litigation has already been accepted by the division bench in case number such and such. Simply was disposed of the number such and such. They was to give an appropriate decision concerning the question of the appointment of the persons whose names are put on the select list of the candidates by the National School Service Commission in connection with the regional selection test 1998. It is submitted that in compliance with the single bench order, July 7, 2000, the secretary has given a decision and that persons whose names are in the list prepared by the regional school service commission would be entitled to recommendation for appointment according to the respective qualification of the certificate. What's the benefit of the deletion of the subset? In view of the aforementioned situation, I dispose of the this order importance that the respondent shall give the petition a benefit of the decision of the office of secretary 11/17/2008. If his name is put on the list concerned, the benefit shall be given within the 4 weeks of the date of publication. In terms of these decisions.
To cut short the matter, Miller, just kindly see their circular notification from the government, Miller.
Additional government secretary.
Address to the GTA.
Address to the GTA lordship.
Will cut short. Next page is, Miller, it is so legible, Miller. Same, because it is the office file from we have made a photocopy. একটা কপি দিয়ে দিও না
Copy.
ওর হ্যান্ড
এটা আমাকে
Yes, this has been considered. This has been considered if the covered by the division bench judgment or other judgment. There are no such extent rules. That's the normals. No such notional benefit is there in no rules. Notional benefit is not intended to have that in the judicial proceedings, the matter is kept pending and will not be given the notional. I am not claiming for financial benefit. The state exchequers are not asking for. But what is the notional? Only the seniority. For completing my service, previous service at the time of retirement, if I get, this is the system and it was taken into consideration all along. There is no such, there is no such rules.
Provision.
Now, provisions. Now your lordships can have a look, please. I prayed for that the notional benefit for that should be given to me. Now your lordships, this aspect of the matter was considered by the division bench and as well as our coordinate bench.
Reported or unreported?
Reported নয়
একটু তারা copy that. This is single bench, division bench?
Yes. No.
সুমন রায় এফিডেভিট ফাইল করেছিল
Affidavit তো
ফাইল করেছিল
ঠিক আছে সম্ভব। Pen and pen. I will tell my benefit non-stop into the paper only from the rest of the answer. It will be difficult.
Yes.
One of the division bench.
অর্জুন রয়
Number 11 is the phase 3 bottom portions. The delay was attributed to the conduct of the authorities and the appointment could not be secured promptly the moment it was crystallized. The remedies to available were sought to be exhausted unsuccessfully. For such purpose, the social justice demand the person should not lose the benefits when the others have actually received the same with the prompt action of the authority. We do not find when of formality illegality of interim order directing the appellant to treat the petition as notionally appointed with effect from 30th to for the purpose of conference. So they cannot say that there is no such provision of the motion. And in terms of this coordinated directions, the order has been acted upon, order has been carried out, it has been accepted by the reading motion.
Yes.
That if your lordships kindly have a look to the writ petition.
My lord, all this writ petition has been disposed of after exchange of affidavit, my lord. So let us examine the his or her records.
Well, it is very difficult.
So unless
Landlord would not go through that. It is after exchange of affidavit.
yes, repeat
This
yes,
writ petition.
yes. See, read,
Is your lordship kindly see the order.
read,
See na?
read,
Yes,
Justice Sinha.
after
দাঁড়া না বাবা একটু।
Justice
আমি
Sinha,
file
so-
Yes, I do not read. Please, you read. Yes, I do not make any homework. I read then after exchange of affidavit.
After affidavit in opposition was filed.
Retain with the records. I don't.
Shravan Rai, the petitioner participated, your lordship kindly read with me.
No, first
The
line.
petitioner participated in the recruitment process. No, this is the report. Evident innovation filed on behalf of the respondent of court, GTA be written on the records.
Then?
This is not the state evidence.
No.
GTA has said so.
GT
Now,
is the
in
state
terms-
organ.
In terms of this judgment, the GTA has given a notional fixations, a number, a bunch of this. And annex that copy of the decision of the. They cannot take this benefit. That I will give that particular gentleman section of the employee. I will not allow the other section of the employee. That cannot be done in view of the Supreme Court pattern of the decisions. It is not your choice.
But
You
lordship,
have accepted. Have you accepted this judgment or you have preferred an appeal?
but
Let us kindly treat this way.
as we,
Whether they have accepted, if they have accepted the judgment, can they take in a contradiction? When similarly situation, my question would have been otherwise the other things are there. So Shomala, how can I deny that? That I will give that particular benefit, I have accepted this order, after accepting this order, I am opposing this. You, GT authorities have accepted this order, it is not for the state.
but after the exchange of the affidavit, everything
What
should,
do you-
everything should
And
be,
you take on this affidavit,
Yeah.
what
But
factual-
but everything should be come on record, lordship. We cannot,
on record what? If there is any factual dispute, do you say that he is not in service? What is the
no
factual?
lordship, but this,
My lord,
the,
may I?
Because we
My
are-
lord,
the communication by the,
My lord, may I? My lord, today at the threshold of the writ petition, my lord, we do not know what is the contents even. My lord, from the record only, it will be verified whether if he is entitled, definitely.
Yes.
Justice,
Say so, if I am entitled, they will award that.
Mr. Bari, please allow me to speak. I didn't,
Yes, yes.
this is not my habit
Yes.
even. You said I do not study. True. I have a very less knowledge. But kindly appreciate today. Today just we are holding a brief. We do not know the office records. Is the office record speak some other way? So this is required to be disclosed by an affidavit, my lord. Even if my department or authority chooses not to file affidavit, some benefit to be extended, he will be entitled to that. But today filing at the threshold first instead taking up the writ petition, such order how can I assist to your lordship in this regard, my lord? This is my only difficulties, kindly appreciate.
Very well, Mr. Barry, let them use an affidavit, because if they want to use, I cannot come in debate.
No, Mala, I tell you, Mala, the affidavit required if there is any material risk. No problem. They can file an. I am only, my lord, whether they have accepted this. I have, my lord, annexed the judicial decisions. The court passed an order by giving benefit that you issue the appointment letter. That appointment letter was issued after 5, 6, 7 years. Am I not entitled to have the benefit for notional fixation? I'm not asking for any mandatory benefit. Mandatory benefit the state can afford. And I'm not asking against the state. The notional benefit, it has been given in term after accepting the order of the court. It is not denied by anybody. And I have annexed the documents in other writ petitions.
But we do not know the service record. If any disciplinary proceeding has been initiated.
If they have given
Consideration, let him consider and discuss
yes.
it off.
And
If he is entitled, he
if
will
they have,
get. If he is
but
not
on-
entitled, he will not get.
and if yes, if I'm not entitled, not entitled. If they have accepted this order, you
Who
have
is-
similar circumstances.
Who will consider the DI?
No, one of the respondent, but director of the executive directors, 2000 department.
But Malad, kindly record in the order, we have chosen to file an affidavit.
Yes, Lord.
Record the order because otherwise,
Very-
Malad.
Even the GTA also wants to file.
Very well, I'm
Because-
disposing it off, directing them to consider, because
Yes.
it's not that
Because
I am
this is,
passing
Milord,
any orders.
what will happen now, Milord? Then the again a second round of we don't want. My view was that definitely if he is entitled, we come up with the instruction with a positive note. Yes, he is entitled. Or
Let
if-
them, let
Mr. Bari, Mr. Bari, then Malad,
the person order.
This
I'm
much
not
of-
entitled.
Let him make his submission.
Yes.
if he is not entitled, we will tell that this is the reason he is not entitled. So this is the reason, Milord, then let us go through the records once.
No,
Let us
but
have an
if
access
the
to
writ
that.
petition is disposed of at the threshold,
Lordship,
directing
dispose
the
of-
authority to consider it and pass a reasoned order.
Malad, consider,
the
Malad, to some extent your lordship can understand. Because the moment it has been approached to the honorable court, Milord, by invoking writ jurisdiction, because they have not considered this is the reason the writ jurisdiction has been invoked. Again, sending back, Milord, the same, whether the purpose would be.
No, at times it works because affidavit in opposition, reply and hearing takes longer time than
Here,
consideration.
Milord, the report your lordships. I understand. The hearing of the petition, exchanging
Because
of.
I would have called for report if
But
there was an
Malad, one
effect.
thing may I ask, I'm asking myself, suppose now it is delayed for exchange of affidavit. Notional benefit is not given, even this such delay would be when it will be determined or decided. That benefit would be given from the date of retrospective effect. So-
No, the problem is if no.
Even when he is not asking for a monetary benefit, at the time of retirement only, he is retirement not in Milord within a very couple of months. So how he will be affected, jeopardized?
I tell you, Lord.
Kindly give us 2 weeks time, Lordship.
Notional, I think to understand why they are opposing this kind of.
This is our duty to.
Yes, that is the duty, not to duty of the states, my lord, to prevent the injustice, and the same time justice should be given to the who have.
Yes, who are entitled, justice should be given.
Yes. So, my lord, I have made an applications. What I am saying, that this aspect of the matter, notional fixation, has been considered by the GT authorities in respect of the others in terms of the court's relation. My lord, they will consider if I am similarly situated. They will extend that. If I am not, no problem. What's the problem? If I am not, they will pass an order to know you.
I leave it to Lordship.
I will record that you wanted to file.
Yes, this is my Milord, I have
No, please
explained
record.
my difficulties
I will
and then I leave it to your Lordship, definitely.
Because unnecessarily.
Yes, Lordship, that's true even. That's true even unnecessarily. Even suppose now we are rejecting. The second round of.
They will have reasons then.
Yes.
The oppositions will.
Yes, there must be a reason. There must be a reason. Because now today are asking for notional benefit without any Milord, the state exchequers being affected. But below the such benefit is given, the second round of litigation will come. Such benefits, why not to be extended?
Why are you expecting that?
I can explain. We can dream.
You are here to give the justice. to your city.
If you are not entitled,
I am not entitled, not entitled. The court will not, if I am not entitled, court will not pass any order for entitlement. Court is here to give
Very right.
justice.
Take down.
প্রথমটা 30 33 means. Or should we wait?
Please wait. That will create confusion.
Lordship, before rising, Lordship, one small thing.
It is already
Item
2
number
now.
107.
It is already quarter to 2 now.
Lordship directed.
Mr. Mujumdar is attending virtually.
Malad,
Mr. Mujumdar is there.
Malad, kindly permit me. Malad, kindly permit to Malad mention one matter virtually, Malad. Malad, my junior in the morning mentioned one matter. It's relating to a rally on 21st. Your Lordship asked us to file the matter and matter will come up on Thursday. Malad, little upgradation if your Lordship can take up this matter
It
anytime
will
on
be
Thursday.
taken
Malad.
up in usual course because Mr. Mojumdar, I have not allowed upgradation to anybody. So
I understand, Malad, completely agree, completely agree.
let the system
completely
continue as it is. It will be taken
Yes,
up.
Malad, I shall come Malad, physically and do the matter before your Lordship. Malad, on
Lordship,
21st.
item number 107, Lordship. Yesterday it was listed as item number 128. Mr. Aniruddha Chatterjee mentioned the matter before your Lordship. And Lordship was pleased to tell that the matter will be taken up on Thursday and it will be included within the first 10 matters of the hearing matter.
But the first 10 matters I did not promise. I said it will appear in the hearing list.
Yes.
I did not promise first 10 matters because I have not been upgrading any matter. Let us see. I am not in a position to upgrade because one upgradation will mean everybody's upgradation. That I cannot do. So therefore, I will not take exception or make exception for him.
My lord, second time will be expecting the Lordship at what time? It's already 10 minutes now.
I will sit within the time. I will not have my lunch. I'll come back at 2.
My lord, so far the notional fixation is concerned. Item 33, 34, 45, 33.
No, but the appointment letters and all dated, dates are same.
No, not dates are same. So judicial proceeding was pending. The date if your lordships, we can mention here, or one after another your lordships can do.
Yeah, item 33 is similar to which one?
Similar to
31.
31.
31.
31. 31.
Notional benefit.
31 आपने नहीं चले? Thirty-three to
33, 34, 35, 36, 41 and 42. These are the same email.
33 to 36.
33, 34,
41, 42.
41, 40. These are the notional fixations.
These are similar to item
31.
31.
Only the dates.
That out is similar to item 31 लिखेंगे. Similar to item 31 लिखेंगे. And the other one?
No, other one might not be, they have taken time, giving the list of it. They
Yes,
have taken time for filing
report.
For filing report.
No, Lordship, but copy has not been received yet.
No, we have sent a copy. They have not received that yet. On last Friday, we have
So
sent.
then let the
They have
copy
not
receive.
they have not accepting the, by hand.
Yes,
So,
Lordship.
we have sent it by post. Say, I have inquired.
Because I have no direction to
No,
receive.
very well, no problem. Your lordships kindly, but item number, let it adjourn for 3 weeks. Come, circuit, I will be difficult.
देखो.
Item number?
Item number?
72 to 81, 72 to 84, except 82. These are the, let it adjourn for 3 weeks.
72 to 84.
72 to 84, except 80. Because their report, one report will cover everything. So simply adjourn for 3 weeks. They have taken time 2 weeks, 1 week. So let it be adjourned for 3 weeks.
So here
Lordship, let the copy come first. Lordship.
I'm adjourning it. I'm not passing any order. Don't worry. These are 72 to 81.
72 to 84, except 82.
72 to 81, 83 or 84. 82 का बाद दिए पहले 72 to 81 और 83 and 84.
Adjourn for 3 weeks.
এটা একটা order record করে.
In all matter, I am appearing on behalf of the chief.
72 to 81 or 83 and 84. Same order record. It is submitted on behalf of
Yes, that's right.
হ্যাঁ দুটোর সময় ফিক্স ম্যাটার এটা
আচ্ছা, ধরো, you have to catch the plane out.
My lord, item 85.
No, not yet, not yet. Please wait.
Oh.
2 p.m. fixed item 85.
Yes, there are 2 p.m. fixed matters. 2 p.m. fixed. Dekhi.
Lord, I beg to appear on behalf of the Lord respondent, the second appellate authority, West Bengal Information Commission.
Mr. Saha and
Lordship.
My lord, I beg to appear for the
Banerjee.
petitioner.
Yes, yes, Mr. Banerjee and Mr. Saha, both of you.
Yes,
I
yes.
will place these matters today because I thought I'll be considering it because yesterday I was pressed. I could not do my research. Can we have it tomorrow at 2 p.m.?
No
Yes,
issues.
yes, my lord, just one indulgence, my lord. I have, my lord, am I audible, my lord? There are
Yes,
some
yes.
network glitch. My lord, my lord, just one indulgence, my lord. Two of judgment, my lord, very short, just only one paragraph, my lord. I would like to rely upon my junior is
Side.
over, my
Side.
junior is over there, my lord. She will hand over. One is, my lord, this is 2011 4 ULG 59 HC.
Yes.
This is Arvind Kejriwal matter, my lord. My lord,
From the same matter relied upon by the RK Jain.
item number corporate 85
my lord, paragraph 9, my lord, is relevant portion.
Lord, can we have the cost title of this judgment?
Yes.
State Information Commission, no? Respond number 6.
Is Arvind Kejriwal and Central Public Information and another. In the Court of Juncture, Delhi Division Bench, Honorable Deepak Misra, 2114 ULG 59 HC. 2114
Yes, I've
UL.
seen it.
Yes.
Yes, next, which paragraph?
Yes, my lord, this is one, my lord, only one paragraph, paragraph number 9. And my lord, another judgment only for one line, my lord. I will relied upon. This is 2003 9 SCC 731. State of Maharashtra and others versus Jalgaon Municipal Council and others. Rishita, kindly hand over the copy.
Yes, I've got it.
My lord, the second last page. My lord, straight away come to the second last page.
Yes.
My lord, the top 3 line, 1, 2, 3, 4 line. And thereafter, my lord, from the top 4 line, one of the principles, my lord got one of the principles of good governance in a democratic society is that smaller interest must always give way to larger public interest in case of conflict. This is on good governance, my lord. Paragraph 37, a portion of 37. A portion of 37. This is a matter in relates to, my lord, municipality matters, but this is very important for the purpose of good governance, my lord. And my lord, as my lord, yesterday, my lord, when I placed the judgment, my lord, and my lord, that was fallen from your lordship, that paragraph number 45 of Aditya Bandyopadhyay judgment, which was against of me. But my lord, done a part of research on that. The fiduciary relationship, my lord, is a separate provision. This is on section 8(1)(e). This is not applicable on me, my lord. They have stated this is 8(1)(j), my lord. My respectful submission is, my lord, if all the judgment which I was relied upon, my lord, they have categorically stated very clearly, if there is a public interest and for the purpose of the public interest and for the purpose of good governance, my lord, this can be done. And section 8 is not also an absolute bar, my lord. proviso portion of section 8(2). There is a proviso, my lord, in what cases?
Mr.
in
Banerjee,
which-
I will hear you tomorrow. I said,
Yes,
no, there's no purpose
Yes,
wasting time. I'll
But
hear you.
only
Yes,
one
yes.
line, but
Yes,
only
yes.
one line. But the public purpose is always there. But everywhere, whether it is not the statute or the Supreme Court
You
judgment, my lord,
consider these, you consider these.
I will
judgments from
certainly.
tomorrow,
The thing,
not
my
today,
lord,
not
the
today.
discretion was
My lord,
entrusted
my
upon the
lord,
commission, my lord.
my lord, only one
I will
indulgence, my
decide
lord.
it. That is why I'm taking time. I'll
My
decide
lord,
tomorrow.
my lord, only one indulgence,
Please go
my
this
lord. My lord, instead of tomorrow, can it be a day after tomorrow? Kindly, my lord.
Day
kindly.
after tomorrow may be difficult. That's the hearing day here.
Oh, tomorrow. Kindly, my lord,
Tomorrow-
2 p.m., my lord. My lord, kindly.
2 p.m. 2 p.m.
2
Tomorrow 2
p.m.
p.m.
Grateful, my lord.
Grateful,
Grateful.
Lord.
Grateful.
Adi, এখন ফেরত দিন।
Grateful.
Item number 86 also tomorrow 2 p.m. Tomorrow, not today. Tomorrow 2 p.m. Very well, madam. Because there is a pressure of motions. I'll
My lord,
just
I will
get
keep
rid of it.
one judgment for clubbing in the record for my
Yes, yes. Show me.
My lord, a
I've
copy of
kept
the
this-
same may be given to me, my lord.
I've kept this because I want to take some time out for myself.
Yes, yes. My lord, this is the rectification what my lord has asked. This is for the এটার মধ্যে হ্যাঁ এই দিচ্ছি এটার মধ্যে কি ক্লাবিং দেওয়া আছে ক্লাব হ্যাঁ এটাও রেকর্ডের মধ্যে দিয়ে দিই হ্যাঁ এটাও কি না পর এটা দিই
You মানে কি judgment গুলো দিলি আমাকে একটু বল। বলো।
আপনি এদিকে দে এদিকে এই ছবি আমি ছবি তুলে দিচ্ছি দিয়ে দিচ্ছি সেটা
এটা আমার লাগবে। তুই একটু ছবি তুলে নিয়ে নে।
Yes, both of you do some research and come.
Yes, my lord. Yes, my lord.
I thought I'll be able to do yesterday some research, but I could not. I was held up till almost 5.
No, I
in
do.
court.
Tomorrow at 2 p.m. my lord.
Only one judgment you have given.
Yes,
ওই judgment কোথায়?
My lord, only one judgment আছে। Judgment টা কোথায়?
My lord,
Samrat Samunto and mother.
This is on what point?
On
clubbing
question.
of clubbing. The last, my lord, is the last part, the last bit, a clubbing. The last part, it has been mentioned that it has to be clubbed.
Yes.
All dates shall be clubbed. Tomorrow 2 p.m. my lord.
My lord, I'll see to it. I'm grateful, my lord. না নাম দিনে 86 That's true.
My lord, 32, I appear on the petition.
Lordship, in item 32, I am appearing for the commission led by Dr. Patro, my lord.
Lordship, you represent the state inspector.
Lordship, we are informed by this of this matter few minutes back, my lord. We need to take instruction and go through the deed. We have not received a copy of the writ application also.
Commission has
Copy
not received a copy of the writ petition.
Copy it was sent.
We need to go through the annexures and the document they are relying upon, my lord.
And they want to go to the.
They said they have not received a copy of the writ petition.
Literary copy by me.
32 not the copy.
42.
32.
32.
32.
32.
Yes, my lord, 32.
দেখ 32 কিনা দেখ ভালো করে দেখেন
No, no, it's 32 only.
32 মানে this is I tell you lordships, these are validly recommended by the school service commissions. We are the teachers, very unfortunate teachers who lost our job by virtue of the judicial proceedings. Now, my lord, in a other batch, this is the 2016 process, entire block was cancelled and set aside by the Supreme Court, our High Court division bench. I participated, my lord, as a upper primary teachers and become selected. There is a difference between the 9, 10, 11, 12 and upper primary teachers up to class 8. To show my lord, I have been recommended. Within 90 days, the rule says that within 90 days, the recommendation is valid. And thereafter 60 days, commission may extend the lifetime. Now we have been validly recommended. We prayed for time. That time was not given. Now only the question arises for extension of the time so that I can join this schooling question. These are the short questions. Now, my lord, the school service commissions, it appears that I want to join. I made an application before the school authority. Your lordships kindly have a look to the page 29, if your lordships kindly. I, Kolpita Rai, qualified candidate of the first state level selection test, recruitment, the assistant teacher of the upper primary level 2016, beg to inform that after all the procedure, I received a recommendation letter, but I could not join the post as I was serving as assistant teacher after qualifying SLST 2016 and awaited for final verdict of the Honorable Supreme Court and hoping for continuity. Apart from that, I have. Your lordships got it. Now, my lord, I prayed for. Next page, the prayer for joining to the post of the assistant teacher in upper primary level. I prayed for. It appears, my lord, I have given the document. The school service commissions has allowed a bunch of the candidates. Your lordships kindly have a look.
Prayer of yours.
That has not been considered. That has not been done. Now, my lord, yes, your lordships kindly. Yes, now.
Madam, for the commission.
Yes, my lord.
If I dispose this of directing you to consider the petitioner's prayer in the light of the relevant rules, that will do. You will consider and dispose of.
Yes, my lord.
My lord, I will be relying on judgment. Lord 17, your lordships kindly. 17.3, your lordships kindly. 17.3. 60 days, thereafter 90 days. The commission may extend the time of further 90 days, further 60 days, 90 days plus 60 days. That was not given. Now, my lord, this aspect of the matter was considered by our, it was. I had occasion to argue this quarter before justice that. Your lordships kindly have a look to this same point. WP. No, listen on. Every service. তো পড়েছি এসব আপনারা স্যার আপনার বইটা কবে বেরোবে এখানে এখানে রেখে দিই না পিছনে রেখে দিই
Similar matters are being heard by the coordinate bench, my lord. And in some of the matters, there is direction to file report by the commission.
Yes.
Now this is if your lordship remitted back to the chairman and if he takes decisions and already they have taken a decisions a bunch of the matters.
They'll take a decision.
Decisions.
They'll take a decision. It is within their authority.
Within because it will lapse and your lordships can leave past an order.
Yes,
they will take into consideration of the judgment we shall place with them.
I'm remitting it back to you. You take a decision.
Yes, my lord.
You dispose of the representation made by the petitioner in accordance with law.
Yes. Yes, my lord.
Respond number 4 is the chairman, West Bengal Central School Service Commission.
The petitioner.
My lord, it will be because
My
the
lord.
expiry, it will within 2
Uh,
weeks if your lordships can.
Within 2 weeks.
My lord, the selection process is going on, my lord. Kindly give it 4 weeks, my lord.
The expiry will be this is the
Because
problem.
the validity extension will expire within a few days then.
Yes, my lord.
Let
3
it
weeks,
be
I'm giving 3 weeks. 3 weeks.
3 weeks.
Period of 3 weeks. I have directed the chairman to consider the representation made by the petitioners in the light
ma'am.
of the judgment delivered by this court in WP 2380W of 2014. There is a judgment of Piali Biswas versus State of West Bengal.
Yes, my lord.
He will decide the representation in the light of this judgment.
Yes,
And
my lord.
commission already extended. I have annexed the document also. Your lordship, kindly see the last document. Last. They are doing so. It is not the fact that they are.
Mr. Bari also invites the attention of this court to
Page 31.
notice the uh, 1289 of 2020.
Grateful, Lordship. Lordship, the only thing is, the court fees may kindly be taken.
Yes, we have given the court fees.
To
No problem.
petitioners.
Yes.
Let
the document be kept on record.
Deficit court fees has একদম উপরে লেখা deficit court fees have already been
আমাদেরকে বলতে হয় না এগুলো।
The document evincing such payment is taken on.
Grateful, Lordship.
Next also same.
37 and 40.
37 is the same.
37 and 40.
42.
37 same.
Yes, Malak, 37 same, only the date and prayer of the before the chairman, page 24. Recommendation. Candidates are same, but the first SLST of the upper primary, expiry date, recommended. The facts are same, date are different.
Dates we will.
Yes.
I'm attending for the commission in these matters also, my lord, like the Dr. Patel. Yes, my lord.
Another can
recommendation letter of SLST 2016. 37 next. 37.
37 quarter. Yes, 37 disposed of.
40.
Same, there is only one petitioner here.
Only one.
Yes, Lordship.
একজনই আছে
40 or same, sir.
40 or same too.
I'm for the commission.
40 also same.
40 also same.
40 same একজন আছে petitioner.
Huh? Only 4 months. Oh, okay.
40.
Well, same. তাই তো হয়ে গেল সব কটা তো কোনটারে
Grateful, Lordship.
39 কে আব্দুর রহিম মিয়া 39 39
38 call করুন 38
39 তো
38
38 আমাদের নয় তো
Well, in 38, I am for the private responsibility. My junior is there. Am I audible, my lord?
Yes. 38 petitioner.
Well, this is that matter where your lordship has got this order of 30th June. Maharaj Justice Ghosh has been to
fix the two matters. One is appearing yesterday also when the two matters was appeared. My lord, I was there. The petitioners took adjournment. The earlier also took adjournment. Several adjournments were there. And
এর সঙ্গে আরেকটা কিছু আসার কথা ছিল না?
but there are another read petitions for the order is there.
That with this matter, this is 31620.
And well, the allegations, well, the two representations were there of the same dates in two read petitions.
Only one of them is appearing today, the other is not appearing in the list today.
Well, your lordship can take up this matter also, or your lordship can take up tomorrow both the matters, because this was appeared. Your lordship kindly recall yesterday both the matters.
Very well, I have understood. Chal, record করুন। রেকর্ড করবি না। It will appear in the list day after tomorrow.
But day after tomorrow, your lordship is taking up the hearing matter. So far,
So it will appear hearing matter. After hearing matters, I'll take.
Well, this well, kindly appreciate. Well, this is waiting.
What is the problem? There is no interim order that has been passed. What is the problem?
This is on our aspect. Well, these peoples, those who are added, and some of them has not been added. Well, so well, the
Very
allegations
well, no order has been passed on the writ petition. I don't find any reason.
They are well, publication.
Very well, I have said after tomorrow it will appear day after tomorrow. Please don't waste time on this.
My lord, I'm only let it be taken up day after tomorrow, but my lord, let it be on top, my lord, because this is since long it is appearing.
No, 39 I appear in the petition. Well, the subject matter of the challenge is the impugned decisions of page 37.
Page
37. Before that, your lordship kindly 37. Before that, your lordship kindly. Before that, your lordship kindly consider the
39 item 39 D. এটা অন্য ম্যাটার বলছে।
অন্য ম্যাটার দিয়ে দিন।
এই ভিডিও ছাড়া করা যাবে না, অর্ডার আছে না একটা, এবার ঠিক না।
বারোশো 96।
ভিডিও কিছু কোন এর ক্যামেরা রিপ্রেজেন্ট করি তুমি
মাদ্রাসা কি না মাদ্রাসা
আমাদের কিছু
পাবেন না কেন? দেখ তোমাদের কোন ব্রিফ আছে কিনা দেখতে হয়। এর মধ্যে আর আছে একটাই আছে না?
ব্রিফটা মিস হয়েছে আমার, ব্রিফটা মিস হয়েছে। হ্যাঁ আপনি টিচার ছিলেন আমার পড়াতেন যে।
May I hand over my brief to your lordship?
File should be there.
No, brief is certainly there. This is the last matter I shall be doing thereafter. I will leave the court.
Not let a passover করে রাখ time being.
Should I?
Passing it over for a time being, let the file come. পরেরটা ডাকুন। 40 হয়ে গেছে।
40 হয়ে গেছে।
আমাদের order.
I for the respondent.
I for the state response. None appears for the petitioner. Full stop. The respondents are represented. এটা রেখে দিন আবার
Page 33 is the impugned order. Decision of the court.
33.
Page 33.
Yes.
The petitioner was appointed as a group D staff, the managing committee of such and. Got it, your lordship?
Yes.
In October, 1st October 2007, permanently on usual salary, subject to approval of the DI of the school for year, the petitioner continued the such work uninterruptedly at least 15 years. Subsequently, the permanent sanction post group D in the has been filled up by the Osman Mother Service Commission, ignoring the petitioner claim for being regularized taking as such permanent sanction for.
You want similar orders?
Petitioner prayer for regularization.
Yes, Mr. Bani.
The court passed an order for creation of the supernumerary post if it is possible.
If
Now,
it is possible.
If it is possible. Now, my lord, your lordship kindly see the decisions. Page 37. Now, my lord, my prayer is twofold. One, at the time of appointment in 2007, the Madrasa Service Commission Act was not in force. The appointment was made by the school authority, managing committee, and this appointment at best, my lord, can be said irregular, not illegal, against the permanent vacant post. Now, my lord, the appointment on following the recruitment rule before the School Service Commission Act came into force was the direction of Commissioner of School Educations that calls my Director of School Educations, the recruitment rules. That recruitment rule was declared as a, well, not mandatory by the Honorable Special Bench. 5 judges bench says the recruitment rule is not a mandatory, or in violation of the recruitment rules, it can be said irregular but not illegal. Mala, I was appointed, I have been serving there. I am told the post is there. But when the authority, the court taken sympathetic attitude towards the petitioner, but the authority citing the School Service Commission Act and other acts rejected the prayer. So, my lord, at this, now the Supreme Court after Uma Devi has changed the view. The Supreme Court, my lord, very recently delivered a judgment in 2-3 lines of judgment, the Jago, one of them, that no, the Suma Devi cannot be used at the seal to the fate of the appointed persons who have been appointed not illegal but irregular way. This is required to be considered by the court. So, my lord, at this juncture, what I was praying, subject to Lord's kind approval, let it be decided after completion of the affidavit. In the meantime, my service should not be disturbed. Whatever I am, the status quo today we maintain. Whatever I am, your Lordship kindly this aspect consider mine. And very recent judgment, if your Lordship kindly, I had a occasion, it will be, your Lordship kindly keep it, this judgment, it will be helpful for other purpose also. That relying the Supreme Court judgment when a contextual, here, my lord, I have been working last 15 years. Now this court, after my lord, the considering the recent Supreme Court judgment, delivered a judgment for regularizing of the service of the petitioner who was appointed at a contextual and give the benefit as par with the government service. Your Lordship kindly consider, and your Lordship kindly after exchange of affidavit, it can be decided. Only, my lord, my service should not be disturbed. Last 15 years I have been there.
Yes. My lord, firstly, my lord, I am representing the respondent number 3, man. For the other respondents, my lord, I've just been informed by the learned additional government leader that I could seek instructions whether I will be representing them or not. Because the Madras Assembly Commission has a different council. Now, regarding respondent 1 and 2, they have a separate council, but in circuit bench they do not appear. I have to take instructions whether I will be representing them or not first.
Now, order passed by the
order passed by the Secretary of Department of Minority Affairs.
Minority
Let me come
Affairs.
back day after tomorrow, my lord. I'll have the instructions ready whether I'll be appearing for them, and then we can.
No, let the exchange of affidavits, no further.
If I do not represent them, I cannot say.
Or whether he can appear.
Yes, I can appear for respondent number 3.
The 3 is the district inspector schools approval. Is given.
Not his order, my lord. His order is not in the service. No, order of the.
I leave it to your lordship. Well, I will. Then my day after tomorrow is the hearing day. Keep it tomorrow. My learned friend will try to take instruction.
Tomorrow, my lord.
Is only half. Second half.
Oh, second half.
Second half, my lord. Yes.
Very.
Notional, I am code number item 43, my lord. This was fixed on day after tomorrow, my lord. Learned senior, my other side also ready? present. Ready, my lord. Dekhi 43 ta din. 43 er order ta kiti din.
It's a simple matter. It's a simple matter. Because so many courts held that the if registration is cancelled, it has to be restored.
GST registration cancellation, my lord, restoration. Yesterday I also given one
coordinate bench judgment to your lordship, my lord. My learned excellency, well, I want to pay the amount and due taxes, my lord.
Whatever the order, because so many judicial orders are there. So there is no purpose keeping the registration cancelled because that will the revenue loss. So this is the opinion of the different courts. So we also regard the same.
The petitioner, the petitioner he doesn't file, then it will not be restored. It is subject to uploading that he will restore. Registration is subject to filing.
No, once we open, then if he is not acted upon for some limited time, then we have to.
That you will do, because my order is that you will register, you will restore his registration upon him complying with whatever is mentioned over there. If he does not upload, then he will suffer the query. ওখানে আরেকটা লিখে দিন। Needless to mention that the petitioner shall upload the return immediately upon opening of the portal.
Lordship, I am for the petitioner. My lord, in this matter, my lord, the prayer of the petitioner is going to be considered. So, Lordship, can this matter taken up, be fixed for the next circuit or go out of list, Lordship? Because this is a tender matter.
It is submitted on behalf of the petitioner that
Lordship, I'll withdraw this matter most probably. Grateful, Lordship.
Lordship, I am for the petitioner. Lordship, affidavit of service. Lordship, in this matter, I am praying for next circuit since the learned council may not be able to come before this court this week, Lordship. I'm led by Mr. Divesh Gupta. So I'm kindly praying for next circuit, Lordship.
What is the matter? I don't know.
Matter for execution of warrant. Lana trial court had issued warrant of arrest, which was pending before the Bhaktinagar police station. It is not executed yet. That is our grievance.
It is maintainable.
Lordship, I am.
Let it be next circuit.
Let's see the next.
Affidavit of service filed today be kept with the record.
I am for the state response.
My lord, item 46 praying for next circuit.
Why next?
Praying for next circuit, my lord.
আচ্ছা ওটা adjourn motion করবেন আগেরটা কি under the heading adjourn
My lord, it is the matter, it is fixed was yesterday, my lord. In this matter, my lord. In this matter, hearing was already concluded as submitted by the learned advocate yesterday, my lord. They have made a representation before the subdivisional controller as well as the district controller of food and supply. And today is fixed as because they have apprised your lordship whether hearing has been concluded or not. If hearing has been concluded, my lord, the matter is automatically.
The matter will become infructuous. That was what the submission was.
Apology, my lord. I had no idea about the fact. My lord, kindly make it a short passover.
Passover. A call করবেন.
Yes.
Passover. Next. Call put. একটা call. দেখি
I am for the statement.
হ্যাঁ লিখুন না PS for the petitioner. Five minutes.
Yes.
Yes. Passed over. Passing it over. Pass it. Next.
My lord, I beg to appear on behalf of the petitioner in this matter. It
Yes.
is that matter of lien your lordship was considering, and I have been struggling to do the matter since last week. My lord,
Where is your other
your lordship
side?
this is the problem. Every time I try to make an argument, but they are not available. My lord, difficulty is 7th was the last date. Though I filed the writ petition previous to 7th, your lordship has already heard me.
They had appeared on the first day. but
Yes,
then
yes, they appeared. They appeared.
We could not take it because of the 330 resolution.
Yes, my lord. Yes.
Can you bring the other side? I'm passing it over. You are there.
No, madam. Yes.
From Jalpaiguri District Primary School Council, the learned advocate.
They are before court number 2, my lord.
Passing it over. Bring them.
Very well, my lord. My lord kindly takes it up today.
Yes. I'm ready to take up any day.
Yes, my lord.
Your resolutions prevented it. In fact, I was taking up, it was mentioned that
Yes, my lord.
electricity.
Kindly take it today when your lordship will be taking up the matters, passed over matters. Kindly, my lord. Yes.
Condoning the shortfall of service, see 4 months, 28 days. That is covered by the deservice scheme, lordship. That is the chapter 3 scheme, section 7 EIV, lordship. May I submit, lordship? Government has power to condone up to 6 months of service. There is the
My lord, the answering respondent is, my lord, the chairman, DPSC.
no, lordship.
Kuch Bihar, my lord.
Lordship.
State cannot decide.
By the state lordship. Principal
State
secretary.
cannot decide until the clearance is from the DPSC, my lord. DPSC Kuch Bihar.
Kuch Bihar DPSC কিন্তু condoning power স্টেটেরই আছে ডিপিএসসি
আগে তো ওরা আমাদের পাঠাবে রিপোর্ট সবকিছু ডিটেইলস, তাহলে তো আমরা করব।
Who appears? Why is the
Well, DPSC Mrs. Mousubi Bhawal appears, my lord.
There is the several judgment, the division
why
bench
is
also.
she not appearing?
That I don't know, my lord. He was.
I did not serve, lordship.
Oh, they have not.
I made party, but I did not serve.
No, then you serve.
Because the answering respondent is a state lordship.
No. So why have you made them parties? If you have made party, you should serve. Unnecessarily, your service on the respondents is not complete. Full stop.
The day after tomorrow, lordship,
Service again will not be complete. Unnecessarily, again, time will be run.
so next two item also same, lordship.
Very well. 51.
51 and 52.
51,
52, same. Service not complete.
I have one of the lordship. I don't have 52 lordship.
For the state.
Yes, sir.
Lordship, I beg to appear for the state in this matter. Lordship, I am seeking for 2 days adjournment, Lordship, in this matter, because yet not I received the instruction from the department.
Lordship, thing is that the one criminal case has been initiated as per the order of the learned SCGM Shiliguri, the application under section 156 subsection 3 of CRPC. As per the order that the case has been registered, it's fact. But till this day, no investigation has been done by the investigating agency.
Then her instruction will be material. Let her come with instructions.
Instruction, Lordship, I am referring one document. I got some RTI. See my document number, page number 97.
Without her instruction, can we proceed? It won't be.
Lordship, regarding the investigation, they are saying what is their information.
Very well,
Please see
but-
90, page
but
number
that
97.
that is your side of the story. Maybe she will come with.
It is not
something.
my story, Lordship. This is a document of the
Very
department.
well. After that, nothing might have happened. Something may have happened. Let her come with this.
Lordship, Lordship.
Because unless I
Lordship,
hear that,
Lordship.
she will not be able to pass.
Lordship, in this matter, I led by learned additional advocate general, Lordship. কবে রাখতে হলো? কালকে না day after tomorrow বলি? Day after. Lordship, kindly fix the matter day after tomorrow. By this time, instruction will come.
Learned advocate appearing for the.
My lord, the appeal for the petitioner, I am led by Mr. Avinash Poddar, who is appearing online.
Lordship, I am for the respondent.
Yes, your lordship, I am there, my lords, appearing for
Yes,
the
my lord, he
petition.
is there.
Lordship, my lords, if my lords may recollect, on the last occasion, my lords, I have tendered one order, my lords,
Yes, देखिए.
covering my matter, my lords. The other side also conceded to that request, my lords.
No, Mr. Poddar, I was going through the matter.
Lordship, please. Lordship.
Why have you approached the court so late? And what is the explanation?
Lordship, for that, my lords, I'll also seek instruction, my lords. The reason being,
Because
they have initiated the recovery, my lord. That may be the reason, my lords, because they have.
Lordship,
because you see, in writ petitions, we have to give a plausible explanation for us to exercise discretion.
Lordship, I do agree, Lordship.
Lordship, otherwise also the prayer will not entertain because the 73 proceeding is
Because
already.
the orders which have been cited, in those cases, the petitioners were vigilant enough. They appear to have approached within time.
Otherwise also he has got the alternative of appeal, Lordship, because the matter is traveled for the adjudication also in pursuance to the order of the appellate authority and
The concern is that there is no
page
appellate.
91, Lordship, page 91. So now they can file the appeal and show the document, whatever.
The appellate tribunal was not functioning, is what I was told.
Not functioning.
No, but this fact is quite different. Now what happened? The refund was granted and in the review, it was found that some documents was not uploaded. So appeal was filed. In appeal, they have not appeared. So appellate authority passed an order and appellate authority directed to recover the amount under 773. So jurisdictional officer, as per the direction of appellate authority, they have initiated the proceedings. Now that is also comes to the finality. So as per the adjudication order, as page 91, it is specifically said that there is the appeal provisions. You can file an appeal.
Lords, may I make a submission, Lords?
84 page, relevant page is 84. So whatever he is praying that the old appeal, it has to be set aside, that cannot be in this case. because they are getting the appellate forum also.
But if the tribunal is not functioning, then where is the appellate?
No, no, no. Now, the appeal was decided, filed by the department, and as per the appellate order, direction was given to the jurisdictional proper officer to recover the amount under the section 73. And
Let's
interest,
say we completed lots.
then that order is also passed.
The order of the appellate authority also needs to be challenged. Where will they
Yes.
challenge it if the tribunal is not there? The order in original which has now been passed.
Right.
In terms of the appellate order.
Right.
Is a consequential order.
Consequential.
Right.
Basic order is the appellate order.
Absolutely.
The appellate order is to be challenged before the tribunal which is non-existent. So the appellate order must be challenged before the writ court only, then. Before
But
the
this,
tribunal is not there.
that order is in pursuance to section 54 refund order, and this order is recovery proceeding 73.
These are all
But
consequential.
can I?
That is
can I
true,
reply?
that is true, that is true, Lord.
If the basis goes, then the consequence goes. He has challenged. the
Definitely,
basis.
definitely, but
He has challenged the basis. For challenging the basis, there should have been a tribunal which is not there.
correct.
So writ is maintainable. Otherwise, writ is maintainable. The only question is why the delayed approach? Where is the explanation for delay? That is the only question. Otherwise, writ definitely will be maintained.
But otherwise also, once the order is passed, and in the order itself, it is said in page 84 that you can file an appeal. So now what?
Well,
Right.
that is consequential. If the order is passed.
Correct.
on
That
the
is
basis
I
of an
agree.
order,
Whatever fall from your lordship, I agree.
If the order is passed on the basis of an order which can be shown to be illegal, then I will not comply with that order. I will challenge the basis, knock the bottom of the order, and then I will have.
But the thing is
See,
that
it is collapse.
they will not appear before the appellate authority also and adjudication authority also.
Before
So-
the appellate authority, they did not appear.
No, nothing.
Let's-
And
The proceeding was uncontested.
yes,
Let me hear Mr. Dr. Poddar.
Lordship. Lordship, twofold submission, Lordship. Appellate authority, when the appeal was filed, my lords, we have mentioned that in our pleadings that there was no hearing that we have received. And that was the reason that we could not appear. But secondly, my lords are raising a very pertinent question that why there is a delay. Why we have not approached this honorable court earlier, my lords. My lords, the instruction which I have received was that they issued a letter of recovery in December 2024, my lords. Thereafter, we made an endeavor to approach them and to request them then, since the tribunal is not there, and now since the subsequent proceedings are there, we are in the process of filing a writ, my lords, which we have filed in piecemeal basis because there are 7-8 matters, my lords. The order which I was relying upon is of the same party, my lords. They have filed a writ for the same period, my lords. Again, the same difference was there, and for the subsequent period, they are in the process of filing. But that was the reason wherein the recovery was initiated. That was the only reason, because otherwise, my lords, we were waiting for the tribunal to happen. But unfortunately, now there is no certainty when the tribunal is going to come. So that was the reason that we had to approach this honorable court so as to stop the recovery proceeding, my lords. Because we were never heard at the appellate stage. And my lords, we have already informed them in advance before this appellate order, my lords, even before the original order, that the superintendent has already signed and approved the shipping bills, which were the manual shipping bills, my lords. That was the only reason of the dismissal of the entire matter or the confirmation of the refund. And my lords, my learned senior friend is saying that after passing of the appeal, the subsequent proceedings have been
No,
initiated.
that I'm not satisfied with. But why no notice was served on you for the?
Notice was not served,
yes,
my lord.
definitely. He is saying that we have received, but we are not. But they are saying they are not received.
We
But
have not.
in the appeal, kindly see the page 68, lordship, for a moment.
They are 68.
Personal hearing. During the personal hearing held on 18/1/2023, Santanu Chachari, this is the departmental person, and the respondent did not appear on PS 18/1, though there were the informed regarding the same white letter such and such, dated such and such the number. The respondent neither submitted any cross objections and non-personal hearing scheduled on 18/1/2023. So,
What they did not, Dr. Poddar, did you not receive this letter?
No, lordship. Therefore, my learned friend is reading para 11 of the petition, my lords.
No, para 11 of the appellate order.
Yes.
yes.
No,
Page
minutes,
60.
if I may take to page number 7, minutes of the petition. My government minutes.
Page 5.
Page 5,
Page?
para 7.
Para 11 minutes.
Para 11, okay.
Lordship.
Page 7.
The petitioner is that
Page
on,
7, para 11.
minutes have that? The
Yes.
petitioner stated that on 18/1/2023, the respondent number 2 has provided an opportunity personally against the appeal in form number so and so. However, the petitioner was unable to attend on so and so due to the fact that firstly, as there was engagement function of the daughter of the taxpayer and he was traveling for the same. Secondly, the petitioner informs that he never received the PH letter as he was absent from the business. Minutes, he was not there, so he has not received that PH. That was the reason, and the order was passed. Thereafter, minutes, the subsequent proceedings and then the recovery minutes.
But
And now
Lordship, here it is stated that it is received by the security person. Security. So in the General Clauses Act, if the security is received, it is deemed to be served. Kindly read entire para. The second,
my
is
learned
the
friend is going on merit,
the
then
labor
there
issued
are,
the PS.
there are multiple judgments also.
It was absent from the business, the letter may have been received by the security for which the petitioner was not aware of. His security. And if the security is also received, as per the General Clauses Act, it is deemed to be served.
Not my humble submission would be, Minutes. I have fairly stated the facts, Minutes. It's there is I've approached this honorable court with the clean hands, Minutes. There are judgments, Minutes are aware that there are judgments that if it is not served or communicated to the person to whom it was bound to be communicated, Minutes, it is not a proper service. I'm not going to all those merits, Minutes. Only humble request is, Minutes, may send me back. They let them verify the shipping bills and pass a fresh order, Minutes. That is the only request, Minutes, before this court, Minutes. And had it been a case that they would have not started the recovery proceedings, they have started recovery proceedings, that was the reason we have to approach this honorable court.
Definitely, because once
For the otherwise we will
pass, the department has to oblige the direction of the appellate authority.
Will not initiate the tribunals also, and they will twist our hand in such a way, that is also not proper. Lords, may please see that recovery letter, the mail that they have sent at P14. Page number 20, Lords.
Page number 20.
Page number 99. Page number 90.
98.
99 is the mail, Lords, and 99 is the copy
99.
of recovery of. And Lords, my other submission would be, Lords, once the order is passed, Lords, by the appellate authority, how can a jurisdictional authority can initiate the again a proceedings under section 73, Lords? They can recover under 79. They've initiated the entire proceedings again under section 73.
Yes, Dr. Poddar, you are not challenging the appellate order.
Yes, we are challenging the appellate order, Minutes.
We are challenging. Your prayer does not show that.
Yes, yes.
Well,
that's my learned friend is there, Minutes. He has drafted the petition.
30th of October 2023, I am not finding it.
There is nothing, Lordship.
That's the prayer B, the first part, Milods. Purported order dated 27/2/2023 passed by the appellate authority.
P7 Minutes, annex a P7.
No.
Order is page 84.
Let's annexer P7 is the appeal order, Minutes.
P7.
P7, the appeal order, which is challenged, Minutes, as prayer C, Minutes. If I may be permitted to read.
Yes, Minutes.
Of or
prayer C.
Prayer C, Minutes. Commanding the respondents to transmit and certify the
See records.
There's a mistake, Milord.
It's the records.
Milord, there's a mistake in the prayer part, Milord. The date is wrong, actually. It should be 30/10/2023.
Yes, that is what I'm saying.
Yes. Instead of that, it has been mentioned as 27/2/2023.
That is what I was looking at. The appellate order is not in the challenge. Not P7, it is P11.
Yes.
Yes.
Page 84.
It is 27th February 2023.
P11 is challenged, Milord, but the date is incorrectly mentioned, actually.
Let's P11 is the repeated the second time order, my lords. It's not an appeal order, my lords. If my lords may please
Yes,
come.
yes.
It's not an appeal order, my lords. Appeal order is P7.
Yeah.
My lords, may please come to page number 62, my lords. GST APL 04, the order of appeal, my lords. Page number 62, which is 27th of February
Yes,
2000.
yes, got it. It's there. My mistake. February 2023. Approach in 25.
No, but thereafter the proceedings were 73. They have sent me a letter for recovery on December
So, Lordship,
24.
only one thing, if the order is being passed, whether the department will sit idle, as per the submission of my learned friend, that but the appellate order will be there and you will be sit silent.
No, my lord. Section 79 may be seen, my lord. Section 79, they can initiate recovery. There is no. Let's see if I may submit for a moment, my lord. Just 1 minute indulgence, my lords. Just 1 minute. Let's see what is happening is a superior authority, is an appellate authority. Now, Deputy Commissioner Appeals is passing an order, and an inferior authority, who is the adjudication authority, he is again issuing a show cause notice on the basis of that order is not permissible unless the appellate authority directs him to issue a fresh proceedings. That proceedings are already concluded by the appellate authority. Only the recovery has to be initiated, which can be under section 79 of the Act. For that, the entire proceedings of show cause and the hearing was not required. So therefore, we have challenged that subsequent proceedings also, which is impermissible in law. Because otherwise, the second appeal will fall back, my lord. The second appeal will be meaningless. First appellate authority has passed an order. Thereafter, the adjudication authority is again adjudicating the matter. And then again, I have to go for the first appellate authority. Because second appellate authority, I can go only against the order of the first appellate authority. So therefore, those subsequent proceedings are absolutely illegal, my lords. If my lords may please come to page 62, my lords will be clear about the what I'm trying to point out, my lords. Page 62. Page 62. My lords may please see the signatory Rajesh Tripathi, Additional Commissioner of Central GST, my lords. Page 62. First signatory is Rajesh Tripathi. He is the Commissioner of Appeals, Additional Commissioner of CGST, my lords.
Yes.
Now thereafter, my lords, please come to P8, which is the initiation of proceedings because of that appeal dismissal. The relevant is, my lords, at page number 72. Now it is initiated by Assistant Commissioner. How it is possible, my lords? Against the order of Additional Commissioner, I have to go to the tribunal. If I am aggrieved, if the department is aggrieved, they can go to the tribunal. How they can initiate a fresh proceedings after the confirmation of the order of the adjudication by the appellate authority, and that too by a subordinate authority?
Lordship, I have got the very small submission. There is one misunderstanding. It is appellate authority is not no more the commissioner. His designation additional commissioner, Siliguri appellate commissioner. He is acting as the appellate commissioner. So I will just show the definition. Section 2(8). Lordship, kindly see for once.
What are these then? What are these? 2(8) बोलना है क्या?
Section 2, subsection 8.
Yes.
Appellate authority means an authority appointed or authorized to hear appeal as referred to section 107. So he is the authority to just to hear the appeal. He is not able, he cannot discharge the other duty. So he is no more the senior or junior to the other officers. Here is the, because he is independent authority. We cannot mix up.
So therefore, my lords,
My
after
only Mr. Poddari's time. Petition, discretionary remedy.
Lordship,
After 2 years, more than 2 years.
Yes.
Lords, I bow down to that fact, lords. I cannot run away from that. Lords.
27/02/2023. Order was passed and now it is being filed most probably in the July.
Because the same writ petitioner has approached in 2023 also against another order in 2023 itself.
Right, right. The same.
Yes. I find from the annexures. Yes.
Lordship.
And in the proceeding itself, Lordship, the last submission is that page 91, para 2. The adjudication authority has given the time to produce the document, but what they bluntly says, the taxpayer stated that since the appellate tribunal is not functioning to file the appeal against the appeal such and such, dated such and such, usually Additional Commissioner Siliguri, he will file a writ petition, Calcutta High Court, Jalpaiguri against the order. The same is reiterated to the show cause notice. The writ petition is ready to file and it is not possible to file as the bench is closed due to Durga Puja festival. So these are the submission before the adjudication authority. Relevant page is 91. Because there, if they have produced the document, the matter is over there itself. Because the litigation is that they want to file the 3 shipping bills. They could have filed there. Opportunity is given there.
Lords.
But the blunt statement is there.
Not just one submission, not last submission, lords. Lords, all these are, my lords, the facts, my lords. But the ultimate facts remains that I have exported. There is no dispute with that. Law says that if you have exported, then you are eligible to claim refund, my lords, which I have availed and I have got the refund. Now, my lords, because of a procedural lapse, that it was to be signed by a superintendent, it was not signed by the superintendent, but by the inspector. This is something beyond my control, my lords. They are not disputing that I have not exported. Now, my lords are aware that tax can never be exported. My lords are aware of the fact that tax cannot never be exported. Now, if this tax is asked to be recovered from me, that will mean that because of a procedural lapse, the entire scheme of the law is not followed, because now the tax will be exported. My lord, demanding a tax from me would be like recovering something which was not within the purview of the department to recover. Reason being, my lord, there is only a procedural lapse, which can be, I do agree, my lord, there is a delay, my lords, on the part of the petitioner. But my lords, the only humble submission, my lords, with folded hands would be that this is a procedural lapse and that beyond my control. I have tried to rectify that procedural lapse, my lords, in 2022. It's not that intentionally I have not followed. I have tried to rectify. It was not being undertaken by the departmental authorities, and therefore I had to approach this honorable court. Otherwise, had it been a case, my lords, that they would have appreciated that, yes, now you have that acknowledged copy. My lords, may please see that acknowledged copy also, my lords, at page number 131, my lords. For a moment, my lords, may please see so that my lords are aware that before passing of this order, my lords, we got it signed, my lords. Page number 131. It is 20th December 2022. So we made an endeavor, my lords. We got it certified from the superintendent. We corrected the mistake.
But when you undertook to file the writ petition within 1 month, or you prayed for 1 month's time, as is apparent from page 91, why did it take 2 years thereafter?
Lordship, for that, my lords, I need to take instructions, my lords.
Please take
Because I came into play, my lords.
Troubling me.
Yes.
Because
I do agree, my lords. If one day maybe given, my lords, I'll take instruction.
As a writ court to exercise discretion in such cases would be inviting several other litigations of this nature.
Let's, I do agree, my lords. In that case, my lords, can I request for a day's accommodation so that I can take instructions on that? What was the genuine reason for that?
Please take,
Lordship, please.
as per it,
We'll come.
exception must be there.
We'll come.
Hi.
My lord, service is not effective, my lord. Kindly bring for 2-day accommodation, my lord.
Page, item.
Item number 55, my lord.
State is represented, my lord.
What is the matter?
My lord, matter is, I am the owner of the land, my lord, 2.0.202, my lord. The respondent number 5, my lord, illegally encroached my land, my lord, and constructed a boundary wall over the said land, my lord.
It is submitted by the petitioner that service of service on whom is not complete.
Respondent number 5, my lord, Pradhan.
Who's the answering respondent, my lord?
Yes.
55 state.
Okay, 58, Lordship, we haven't.
Lordship, praying for not today. Lordship, the service has not been affected to the answering respondent.
Why are you bringing these matters in list if service is not?
Lordship, we did the service, but it did not means it is not received by them yet.
It is submitted that service on the respondents is not yet complete.
Lordship, 57, Lordship. Lordship, 57, yesterday the matter had been disposed of, Lordship. Yes, Lordship. Yes, Lordship. Grateful, Lordship. 58. Lordship, 58, we haven't received the copy yet, Lordship. I'm not praying for not today. I am served, Lord. No, but we have not received it from the department yet, Lordship.
My lord, it has been served. It has been served to the answering respondent.
CGST was served last week, my lord. But we have not received any copy yet, Lordship.
Service. I have served it last Monday. It is the fault on their part.
We don't have any
But
instructions.
my lord, there is
Do
an
we have any-
interim prayer in it.
My lord, kindly peruse
We
the
don't have
affidavit
any
of service.
instructions, Lordship, nor do we have any copy, Lordship.
Kindly peruse the affidavit of service.
Fix it not today, Lordship.
What is it that you want?
My lord, our interim prayer is to settle.
set aside the show cause notice issued by the GST, my lord.
Sitting aside is not interim prayer. Sitting aside is.
My lord, that's
My lord,
only
because the goods are
Right.
sent for auction, my lord. Goods are
My lord-
sent for auction, my lord. Some
I'll-
urgency is there, my lord.
Lordship kindly fixes it tomorrow or day after tomorrow, Lordship. Tomorrow is a strike.
Lord, I am led
as-
by Mr. Verma. He's
in-
appearing.
in-
Lordship.
My lord,
Kindly fix it day after tomorrow, Lordship.
my vehicle has been seized since 6th of June 2025, my lords. The only ground in my petition is that he has redetermined my tax liability, which is impermissible as per the judgment of this honorable court in Gurbaksh Singh Gupta, my lords, annexure P12. That judgment categorically says,
Where is the order impugned?
my lords, it's at annexure P11.
Page.
My lords, page 76. My lord, the element is at 81, where he has calculated the penalty by determining my tax liability, the taxable value.
Lordship, we have do not have any document, Lordship.
My lords, the sole ground in this writ petition is, my lords, that I used to supply Ayaka nuts, which was being seized. I charged 145 rupees in my tax invoice. It has not been doubted. They have merely applied 240 rupees, 240 per kg, and they have redetermined my tax liability. The judgment of Gurbaksh Singh by this honorable court by the coordinate bench only has categorically stated that section 129 is a summary proceedings. The officer cannot redetermine my tax liability.
Where is that judgment?
My lord, it's a P12.
Page number. How can I
Page
find?
number, my lords, 90. Page number 93.
93.
My lords, the issue is recorded in paragraph number 5, 6, and 7. What's the sole issue in that writ petition? Paragraph, page number 93, my lords.
কপি এসছে উপরে ছিল
পাই গেছেন কপি
হ্যাঁ।
কপি পাইছেন
না এটা অন্য কেস
ও আচ্ছা
কপি হ্যাজ নট রিসিভড কপি নট কপি নট তবে তো এমটি সার্ভিস
আমি দাঁড়িয়ে ঠিক আছে ছেড়ে বলছি
হ্যাঁ
My lord, from paragraph 19 to 23, the whole the findings of the honorable court is there, my lord.
What is your urgency now?
My lords, my urgency is that my vehicle has been seized along with the goods, my lords. I am ready to give my personal bond, let it be released, since it's completely contrary to the law, completely contrary to the provisions of
Since
129.
they are not armed with instructions, let us hear it tomorrow then.
No issue, my lords. Yes.
My lord, we have not yet received the writ petition, copy of writ
Give a copy
petition.
of the writ petition.
Lord, I have filed
Just
affidavit of
as
service.
per instruction, I am
The
appearing.
writ petition now, instead of fighting over affidavit of service, give a copy of the writ petition so that he can come ready tomorrow. We can hear the matter.
Tomorrow, can it be possible day after tomorrow? Tomorrow,
Tomorrow
there is a bond called by some
online you can appear.
online.
Online you can appear.
Online.
My lord, may fix it a particular time because it might take, I just need 4 to 5 minutes. To
All matters are called on every day.
All
You keep a watch on the list. Every day matters are called on.
And a
Your
copy
matter will be called on. Please be ready with the instructions.
Yes.
Please
Tomorrow.
be ready with this.
Good.
Affidavit of service filed today. We appear tomorrow. It's a Ferod Devi.
Grateful.
আমি চেষ্টা
সেটা দেখুন কার একটা ব্যাগ।
আছো তো কিছু না বেরিয়ে যাবে মিনিট 10 মধ্যে পাঠাচ্ছি
Yes, next.
59. 59 Lordship, I'm for the petitioner. Lordship.
My lord, I am for the state. Before we start, my lord, I have to submit something. This matter pertains to, my lord, District Inspector of School, Alipurdua, because the petitioner retired from service on in the year 1987, and the PPO was issued in his favor in the year 1991. Thereafter, my lord, there is a bifurcation of the district, my lord, and it is right now it is lying with the Alipur district, my lord. Entire record of the petitioner. So it is a Alipurdwar is a necessary party in this. DI Alipurdwar is a necessary party, my lord.
Yes, my representation is before the District Inspector of Schools, Alipurdwar District Circle, page number
is he a-
20. Page number 20.
He has not been made a party.
He has been made a party.
Where?
You have made sub inspector of school Alipur. To serve to DI.
The Sub Inspector of Schools.
No.
District-
DI, you have to serve. Sub inspector.
Yes.
The district, the number 4 District Inspector of Schools, promotion, Jalpaiguri. It should be Alipurdwar.
Yes.
When you said you have made a party.
Oh, no. I was. No, my
He can add
representation
it
is
today,
before
my
the-
lord, and I will
I will add it.
He should also more.
I will make the, I will complete.
Aspirate for leave is granted to the writ petitioner.
Cost delta code. I meant code.
Whatever.
Lordship, for 60, I beg to appear on behalf of the petitioner.
I'm for the still, lordship.
My lord, I am appearing for the DPSC Kuch Bihar, my lord, the respondent number 4. My lord, I am appearing for the respondent number 4, my lord. Okay. Lordship, this application has been preferred on the ground of the compassionate appointment, Lordship. Lordship, the father of the petitioner was died on 27/11/2021 during the course of his appointment, Lordship. So, Lordship, therefore, after getting the age of majority, Lordship, the petitioner applied for compassionate appointment. Before the consideration representation has been filed before the DPSC Kuch Bihar, which is yet to be considered, Lordship. So therefore, this petition is the representation in page number 15, Lordship, annexure P3.
This is the instruction from the DI Lordship. DI is a primary Kuzbihar Lordship. Lordship, several times to ask the petitioner to submit proper documents. They till date no submit the said documents, Lordship.
Lordship, we are not aware of such instruction. We haven't received any copy.
Lordship, kindly see the page.
Very well, he will consider this representation, will give a hearing.
Lordship.
One lordship.
My lord, in item number 60, my lord, direction has been given upon the DI, my lord.
Yes, yes.
Yes, my
DI
lord.
to consider and dispose of the representation.
Yes, my lord.
61, I am for the petition. I am led
And I am for the state, my
Your
lord. I'm
lordship,
led by
I
additional
am
advocate
appearing
general.
for the petitioner. Am I audible to your lordship?
Yes, yes.
Lordship. Lordship, in this matter, your lordship, it is the property of the petitioner which is located. Lordship, for that, the necessary documents are starting from annexure P1. Lordship, without going into the brief, your lordship, I have done the mutation, all the Ds are part of the annexure. Now, lordship, what I'm aggrieved by, lordship, kindly first take the name of the two respondents. The respondents number 5 and 6.
Yes.
Lordship, the 5 and 6 is Darjeeling, Gaon, Chimki, Kalyan, Samaj. And the other one is also the secretary. Now, Lordship, what is the actual background picture? It is the unauthorized construction being done by the respondent number 5 and 6, well within the knowledge of the Darjeeling municipality and also well within the knowledge of the respondent number 4, that is Inspector in Charge, Darjeeling Police Station. Now, Lordship, the first prayer, instead of going into the mandamus, my interim prayer will be in terms of section 218. Like for the timing, let there be a stop work, your lordship.
Yes, who is the
Section 220, I stand to be corrected, your lordship. 220 is the provision
We have served
under the West Bengal Municipal Act 1993. I'm praying for an initial stop work notice. Lordship, what is happening? It is my premises. Now it is my building. Now in the building, I am residing in Calcutta and that is also my house. Now a portion is bounded, but it is vacant. Now your lordship is very much aware, wherever such vacant land is found, illegally people will come and encroach. They will make the party office. They will make the football ground. Lordship, this is what is these are not very welcome, your lordship. No sanction, nothing. If your lordship directs them to produce one scrap of paper, they will not be able to come up. Lordship kindly takes my prayer G, page 16.
Just a minute.
Lordship.
Who appears for Darjeeling municipality?
Lordship, perhaps my learned junior, the advocate on record, Mr. Dhor might assist the honorable court.
How many those?
Lordship, yesterday also when the matter was taken up, Darjeeling municipality is well served. They have the knowledge of the service, your lordship. Still, they are avoiding the service. They're not appearing before your lordship.
And
Lordship, we are aggrieved by the day-to-day construction.
Private respondents have not been served.
Lordship, all have been served. The affidavit of service is handed over yesterday, your lordship.
Private respondents addressee cannot be located. Item on hold. Oh.
Lordship, it is on my premises. Lordship, it is on my premises.
That I understand, but they require to be heard.
Lordship, they are required to be, lordship, the difficulty is that
if in any case if in any case it is found that the construction is unauthorized, it will be pulled down.
Lordship, I bow down to that. Lordship, if I may make one statement here, Lordship. Yesterday also the matter was taken up and the respondents are not appearing. Lordship, the difficulty is that whenever it is a plight of the petitioners, we are aggrieved, we try to serve, we try to bring the
very well, I am recording in order.
Service.
Neil.
Lordship, there is a Lordship, may I make one humble prayer? Lordship, along with this writ petition, I have also filed WPA. I have also filed WPA 1329 of 2025. This is
there in
also
the list.
filed by the
It's not
same
there in the list.
petitioner
It's not there
regarding
in
the same plot of land. It's a police in action.
If
Lordship may
Lordship-
direct both the petitions to appear
Very well, it
together.
will appear in the list. Let it appear.
Lordship, let the two appear. In the event the respondents do not want to appear, your Lordship, in that event, your Lordship, the police may be directed. They can at least find the whereabouts.
Very well. Let us deal with this writ petition first, which is there.
Lordship. Lordship, may I pray for some protection today?
No, madam, the municipality is not there. You have not been able to serve the private respondents. Private respondents have not even been served. Because the order is directly against the private respondents. They have not been
Lordship,
served.
we are praying for an order upon the municipality, Lordship, an interim prayer.
Yes, municipality, order on the municipality for stopping a construction done by the private respondents allegedly on your property. Now,
Lordship, I
whether it
pray
is on
for a
your
leave.
property or on private respondents' property, this prima facie has to be
Lordship, it is my property.
clarified.
That's why
That is your
we have relied
submission,
on
something.
Annexure P1.
Madam, should I pass an order only on your submission or should I hear
Lordship,
them?
absolutely not. Lordship,
Then-
the respondents are to be heard, your Lordship.
Then
Only
definitely,
prayer is
service
also
at least
leave.
has to be effected. Service on private respondents is not there. It says item on hold, not located. They have not been served.
Lordship, the difficulty is that they are not receiving.
It has not even returned to you. That is also not the service. So let us see whether they are served or not. You have sent it only on 2nd. It has reached the authorities on 4th.
Lordship, it has been
We are on
delivered.
8th.
Lordship, it has been delivered. Lordship, kindly records. 4th July 2025, Darjeeling HO, item delivered. Item delivered to your Lordship. Item delivered to the addressee.
Before me, there is an affidavit of service which shows on hold.
Lordship, it's of the earlier date. I am
Very
speaking
well,
of
whatever. I'll
4th
record
July.
whatever is there. I'll
Lordship,
record
you
whatever
can,
is
Lordship
there.
may very
Madam, we
kindly
are
record my
unnecessarily
submission.
wasting time. If it has
Lordship.
been, when was it served? When was it
Lordship,
served?
4th July. 4th July
4th
item
July.
delivered.
4th July, I have it. It says addressee on item on hold. Addressee cannot be located.
At 16:06 p.m. it is delivered.
It says at 16:06:42 item on hold. Addressee cannot be located.
Lordship, my report shows item delivered. The same it shows item delivered. I can obviously share this
You will
screenshot with
believe
the
you will believe your learned advocate on record. Please inquire it
Lordship,
from him.
Lordship,
I've
Lordship,
handed it up
I'm
to
not
him.
raising any dispute on that. Lordship, since I have it in my own hand, your Lordship, I was only
I was
trying
also
to.
seeing from the affidavit of service only, which was
Lordship, it is the recent update. Lordship, what Lordship? Lordship may kindly pass necessary orders. I was only trying to indicate that they have received.
Madam, I'll go by what is there on record.
Lordship, I bow down to that.
Your
bow
mobile
down
phone
to
is
that.
neither near me nor before me, nor can I take that on record.
Lordship. এটা তো দেবশ্রীর কাছে থাকতে হবে
Yes.
49, item 49.
Item 40. Grateful, my lords.
They're giving much trouble to Lordship. Yes, Mr. Lady.
My lord, I am appearing on behalf of the petitioner in this matter. 49 item.
49,
62, not today, not today.
What not today?
49, Kobe wishes.
My lord, I am for the petitioner. It is that lien matter.
Yes.
Yes, my lord. My lord, just for short recollection, my lord, the petitioner was initially appointed as a primary teacher. Now, subsequently, he got appointment at the upper primary level. Now, my lord, he prayed for his pay protection along with lien. Now, my lord, why pay protection? Because since from at the primary level, he was getting much higher, he's getting much higher salary than at the upper primary level. Because of the fact he has rendered a continuous and prolonged service at the primary level.
Who is appearing for the council? I am for the details. Yes, what is your submission?
Lordship, what he is submitting, Lordship, is assailing a judgment and order passed.
No, he's not assailing anything. He
Yes,
says.
there is a judgment, my
he
lord. There is
says-
an order.
He says that he is already working at a place. He has qualified for upper primary. If he goes there, his pay will be lesser than what he is getting now. Now, if he goes there without keeping a lien here, he will have no option to come back. He says that he wants to go there with an option of pay protection. If pay is protected, then he will leave and go there. Till such time that the issue of pay protection is decided, he says that let him join at the upper place and he should have a lien on the lower place. That is the sum and substance of his submission. Is that Mr. Lai?
Yes, absolutely, absolutely grateful.
Yes.
Page 15.
Yes.
Lordship, I humbly submit this is a dangerous proposition who is making.
No, but that is what has been done by the court.
Kindly see page 50, third line.
Yes.
The
Page
the
50.
district primary school council Coach Bihar shall allow the petitioner to be retained on lien as a special case. Now, I find that this case was also the case he is referring was also his case. It was moved by Mr. Lahiri.
Yes, my case.
Now,
Yes.
if taking advantage of this special case, he's bringing all his clients and trying to fit in this special case. Now,
That
what
is none of his
what if-
business. Whether I come with clients and all, this should not be. This submission is not acceptable, my lord. What is he saying?
Mr. Lairi, please wait.
My
What is he saying
humble
about my
submission.
clients and all?
Mr. Lairi, please wait.
My humble submission is, Lordship. Suppose in a case, Lordship,
No, but
if he is allowed,
if you see the judgment, it
Lordship.
has been passed in WPA 373 of 2020.
as a special case,
It refers to another case where similar benefit was again granted. You see?
Yes.
You
Yes.
see page
Justice
2.
Basu's
Page
order.
2. Page 2. Last paragraph. Shudip Bormon's case.
Yes.
Now see page 49
Lordship.
of the writ petition. The one in italics.
Lordship, the problem is, Lordship.
So here also it was done.
I
on
understand.
this basis.
I understand.
May I just
The problem
add
is,
one
Lordship,
thing?
if for example,
What is the harm?
yes, I'm coming to it, Lordship. If this person is allowed to remain to appear in his this higher primary school for 1 year and extended to 2 years for the maximum period. Now, the place where he is at present working, that gap has to be filled by bringing another teacher from another place. Now, if he desires after 2 years that his pay protection has not been settled and the primary pay grade was higher than he desires to come back. Now, what will happen? The person who has been given his share for the 2 years. Now, once again it will be multiplicity
My
of
lord,
scheme.
may I respond to this query? May I respond to this query? Perhaps my learned friend is not
Lordship,
aware of the procedure, how it is done. It is called drafting. A temporary teacher is given at the lien place where the teacher is going away. Lien means to keep the substantial right over the post at the place. Now, temporarily one teacher comes to teach it is called drafting in primary. Perhaps my learned friend is not aware of this procedure. This is how it is done. Now someone comes back, he goes back to his parents' school. This is the answer to his.
So that is the
statement. Now, my
problem
lord,
I am saying, Lordship, that the
no,
the
he's
person
perhaps
from
not
parent
aware
school
of
who.
that. Now, my lord, I make one humble submission.
Lordship,
My lord, the
may I
judgment
return
I'm
with the
making-
written instruction?
My lord, this is what is. This is a settled proposition.
For some time, you should have been.
Lordship, there was another matter regarding this where the similar no, it is pending, Lordship.
My lord, only one
Similar
thing
prayer
I
was
would like
made,
to submit.
and upon our submission, the lien portion was not accepted by the court.
Where is that order?
Lordship, we have to obtain because it was not. It is pending till.
My
It
lord,
is
I do not
disposed of.
think there is any such order.
It is
My
not
lord, only one
disposed
thing
of till
might
now.
the. My lord, may I just make one submission? The
May
order I am
return,
referring
Lordship may
to
come
is.
back day after tomorrow. Day after tomorrow.
My lord, this is how that whole thing is being delayed. This is the whole thing is being delayed in this fashion. They could have showed it in the
They say
first
that
day
there is
itself.
an order, I'm reporting that. He says that there is an order where lien has not been granted.
No, Lordship. That submission was not considered.
Which
That lien submission.
I don't know what
because it was
matter.
not considered.
What?
Another matter.
My lord, this is a vague submission is being made. Some other matter
Same
where
sub-
it is no reference.
Mr.
He
Lahiri,
does
please
not.
let me
Mr.
understand.
Lahiri, please allow me to make my submission.
Yes.
You are ever many
You are
many
making
things.
submission.
You are
You are
ever
trying to
many things
mislead
now.
the court. That is the problem. You are trying to mislead the court.
Mr. Lahiri, please keep your cool. Let me hear.
What I have got the instruction that in another read, this similar type of prayer was made, which was not considered by the court at that juncture. It is pending. It is still pending. Now I have to find out the order. We have searched, but we did not get the order.
Interim order, any order passed?
No, Lordship. It was pending, and the order is, I think, for exchange of this report and other things.
Affidavits.
Affidavits.
What is the number?
Lordship, I don't know. I have just got this information, so I cannot submit. So I want the my department to file a report regarding this. So in black and white,
My lord,
it's
this is.
detailed. Day after tomorrow, I'll return, Lordship.
Now, my lord, may I submit one thing now? My lord, kindly allow me to make my submission for once. The judgment I am referring to, that is absolutely on the same point. Not only this coordinate bench at Jalpaiguri circuit bench, even at the principal bench, it has been settled. Now, my lord, what my learned friend is saying, he should have come with the instruction. It is going on for last 3 days, 4 days. Now, with some direction from you, they will obtain a direction from your lordship to file a report and all.
Mr. Lahiri, if he wants to come back with instructions, the court cannot shut him out. Let him come with the instructions.
Very well.
If you are
Very well.
entitled to an order, you will get an order even after he has instructions. If you are not entitled to an order, without his
my lord,
instructions,
kindly see-
also
kindly
Lordship
see the-
understands.
Yes. Kindly see
At
the
best,
difference. Kindly
I
see the
can place
difference.
the
First, the learned
document
advocate says.
before
First, the
the
learned
document.
advocate says.
Very well.
First, the learned advocate says there is an order. Now, then he says he changes his stand and says
Very well,
perhaps
very
there is
well.
an
Let me
order.
take instructions.
This is how it is a dilatory
the
tactic
writ
to delay the
petitioner-
whole process.
affidavit of service filed today.
The state is also here, my lord.
My lord, your lordship
This
is
is being
fixing
taken,
this matter on, my lord, I could not hear the judgment.
Day after tomorrow,
dictation.
day after tomorrow. Day after
Day
tomorrow.
after tomorrow. Very well, my lord.
My lord,
Very well, my lord.
66 will be
Very
taken, my lord.
My lord, item number 63.
66 or 63, what is
66.
Kolkata?
My lord, I am for
He has to-
63.
He has to
Item
leave.
number 63.
He's going back to Kolkata, my lord. He has to leave, my lord. If my lord,
देखी 66 टा एक बार कॉल करो.
grateful.
Your other side should be there, madam.
My lord, my other side is state and NHAI, National Highways
63 anybody is there? 63. 66 they are there. 63 nobody is there. It's
My
quarter
lord,
to
I believe
5.
there is affidavit of service. If my lord may
Let me call 66 first because both sides are there. Thereafter, if somebody is there, we'll take it.
My lord.
My lord, I appear for the petitioner. The petitioner, as in high school teacher, opted to come under the purview of ROPA 2019.
Yes.
But however, unlike previous years, unlike previous occasions, these times the employees were not permitted to exercise the option individually. They have to exercise the option through the head of the institution via iOSMS portal. And the process was a very complicated one. And at that time, the assistant teacher opted the date 1st November 2017 and informed the headmaster. But headmaster inadvertently entered the date 1st January 2016. And that is the mistake because the employee opted the date falls after his 18 years benefit. And as the date entered.
You want amendment? You want to amend your
No. I would like to amend the option date.
That is what I'm asking. You want
Yes,
to
yes.
amend the option?
Yes.
What is the problem?
My lord, kindly
My
have
lord,
it
there
to
is
page number 33. My lord, kindly have a look. Page
My lord,
number
point
33.
number 3, my lord.
Just a minute. Let me see what they have.
Point number 3, my lord. Here, ROPA rules, no, the option once exercised shall be final, my lord. Thereafter, my lord, the notification.
Page number 33.
My lord,
My lord, have a look. Page number
in
33.
notification, rule 6, my lord, rule 6.4, my lord. The option one exercise shall be final. My lord, our hands are tied, my lord, by the orders of the government.
Page number 33.
Yes.
So this was the past. The mistake was done by the headmaster. And then within 24 hours, I informed the headmaster and I made representation. And the headmaster wrote the letter to the district inspector of schools, and the district inspector of schools forwarded the application to the commissioner. And
Where are the ROPA rules? You have a copy of the rules?
My lord, only the concerned portion, my lord. And
my lord, one occasion, page number 41.
exercise of
Let me understand.
My lord,
Yes, I have understood your problem.
Yes.
My lord, exercise of option. Thereafter.
Yes.
My lord, point 4, my lord. The option once exercised shall be final, my lord. That is the difficulty.
Yes, what were you showing?
Kindly see page number 41. In a similar situation, district inspectors Bakuda had given the opportunity to the teachers of the whole district, those who have made mistake, to rectify their option.
Yes.
My lord, kindly have a look, page number 42. Rule is there.
Page 42. Yes.
42. B. Proposal for change of option.
Yes.
In many cases, sir, I am giving you another example, my lord, page number 44. Previously, many teachers have got the opportunity to re-exercise their option. Because if it is not rectified, the petitioner stands a monetary loss for the infinite time until the retirement, and after the retirement, it will be reflected in his pensionary benefit. Just 18 years before and 18 years after. And this year,
As well. My lord, affidavit of service filed today be kept to the record, or we instruction also?
Grateful, my lord.
এটা কোনটা হলো 66?
66, my lord.
My lord, item number 63. কি হলো